The Code on Social Security, 2020 is a landmark legislation that consolidates 9 separate laws, extends Social Security benefits to all workers across sectors, and creates new protections for gig and platform workers. This reform represents a significant modernization of India's worker welfare approach. The Code on Social Security, 2020. The Code on Social Security, 2020 unifies and modernizes India's social security framework by consolidating 9 separate laws into a single comprehensive legislation. It extends crucial social security benefits to all workers across organized, unorganized, and emerging sectors of the Indian economy. This landmark reform replaces critical laws including the Employees Provident Funds Act, Employees State Insurance Act, Maternity Benefit Act, and Payment of Gratuity Act. Enacted by Parliament in the 71st year of the Republic of India and receiving presidential assent on September 28, 2020, the Code marks a historic milestone in labor reform. It embodies the government's commitment to universal social security coverage and comprehensive worker protection. Key objectives of the Code. The Code streamlines and simplifies the previously fragmented social security system, while significantly expanding protection to vulnerable and previously excluded worker populations. It pioneers social safety nets for the modern workforce, including gig workers, platform workers, and other emerging employment categories previously outside traditional labor frameworks. The legislation establishes robust mechanisms for transparent administration, effective implementation, and consistent enforcement across all sectors. About this presentation offers a strategic overview of the Code's fundamental provisions and transformative potential. For in-depth information, our comprehensive FAQ document addresses implementation timelines, coverage details, benefit structures, and compliance requirements in accessible language. We examine how this code fundamentally reimagines India's approach to worker welfare and social protection for the 21st century economy. Our analysis begins with the foundational preliminary provisions before exploring each chapter's specific requirements and their practical implications for employers, employees, and regulatory bodies. We also detail the crucial transitional provisions designed to facilitate smooth organizational adaptation during the implementation phase. Frequently asked questions about the Code on Social Security, 2020. The Code on Social Security, 2020 is a unified legislation that consolidates 9 previous social security laws, extending benefits to all workers across organized, unorganized, and gig sectors in India. It establishes administrative bodies at national and state levels, and provides comprehensive social security coverage including provident fund, insurance, maternity benefits, and gratuity payments. Below are commonly asked questions about the Code presented in clear, accessible language. These address the key aspects that stakeholders typically inquire about. Common questions about the Code. What is the Code on Social Security, 2020? It is a comprehensive legislation that consolidates 9 earlier social security laws into a single framework. Its primary objective is to extend social security benefits to all workers across India's organized and unorganized sectors. When did the Code come into effect? The Code received presidential assent on September 28, 2020. However, the central government has been empowered to notify different sections of the Code on different dates for implementation. Who is covered under this Code? The Code extends coverage to all employees and workers across organized, unorganized, and other sectors, aiming to provide universal social security regardless of employment status or workplace size. What benefits does the Code provide? The Code establishes a comprehensive framework for various social security benefits including provident fund, insurance coverage, maternity benefits, gratuity payments, and specialized social security schemes for unorganized workers. Does it apply to the whole country? Yes, the territorial jurisdiction of the Code extends to the entire nation of India. Where can I find details about specific provisions? Detailed information regarding specific provisions and their applicability is enumerated in the first schedule of the Code, which serves as a comprehensive reference guide. Which previous laws does the Code replace? The Code supersedes 9 previous legislations: the Employees Compensation Act, 1923, the Employees State Insurance Act, 1948, the Employees Provident Funds and Miscellaneous Provisions Act, 1952, the Employment Exchanges Act, 1959, the Maternity Benefit Act, 1961, the Payment of Gratuity Act, 1972, the Cine Workers Welfare Fund Act, 1981, the Building and Other Construction Workers Welfare Cess Act, 1996, and the Unorganized Workers Social Security Act, 2008. How does the code define employee and worker? An employee refers to any person employed on wages by an establishment to perform skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, or clerical work. The term worker is defined more broadly to encompass individuals in both the organized and unorganized sectors. Key administrative bodies established under the Code: National Social Security Board, tasked with recommending and formulating suitable schemes for unorganized workers at the national level to ensure comprehensive coverage. State Unorganized Workers Board, responsible for recommending appropriate schemes for unorganized workers at the state level and monitoring their effective implementation. Central Board of Trustees, entrusted with administering the Employees' Provident Fund scheme and related programs to ensure proper governance and benefit distribution. Important provisions for different worker categories. For organized sector, structured provident fund contributions, comprehensive employee state insurance, guaranteed gratuity payments, enhanced maternity benefits. For unorganized sector, streamlined registration through self-declaration, targeted social security schemes, improved access to healthcare services, robust old age protection measures. For gig and platform workers, specialized schemes and dedicated funds, comprehensive life and disability coverage, accessible health and maternity benefits, sustainable old age protection mechanisms. This overview presents a simplified explanation of frequently asked questions and key provisions. For comprehensive information and specific implementation details, please refer to the official document of the Code on Social Security, 2020. This landmark legislation represents a significant paradigm shift toward achieving universal social security coverage within India's evolving labor framework. Applicability of Provident Fund provisions. The Employees' Provident Fund applies to establishments with 20-plus workers, with provisions for optional application, withdrawal options, and coverage for international workers. The scheme requires contributions from both employers and employees to provide retirement benefits, with specific rules for contribution rates, withdrawals, and transfers. Standard applicability. Chapter 3 on Employees' Provident Fund applies to every establishment employing 20 or more workers. This encompasses all establishment types across public and private sectors, including manufacturing, service, and commercial enterprises. Optional application. When the Central Provident Fund Commissioner determines that both employer and the majority of employees have agreed to implement these provisions, the Commissioner may extend coverage to that establishment. This flexibility allows smaller workplaces to voluntarily participate in the scheme. Withdrawal option. An employer may apply to exit from the applicability if there is a mutual agreement between the employer and the majority of employees. However, this withdrawal requires thorough review and approval from the appropriate authorities to safeguard workers' interests. International workers. The EPF provisions extend to international workers employed with establishments covered under the EPF Act, with tailored provisions designed to address their specific circumstances and ensure equitable Social Security protection. The central government maintains the authority to extend these provisions to any establishment employing fewer than 20 persons, after providing at least 2 months' notice through official notification. This mechanism enables the government to adapt coverage requirements to evolving labor market conditions and worker protection needs. Frequently asked questions. Below are common questions about the Employees' Provident Fund scheme. What is Employees' Provident Fund? A retirement benefit scheme where both employees and employers contribute to create a financial safety net for workers' futures. This social security measure aims to ensure financial stability during post-retirement years. Who is eligible for EPF? Employees working in establishments with 20 or more workers earning up to Rs 15,000 monthly qualify automatically. Here earning employees may also participate, though with certain restrictions on employer contribution amounts. What is the contribution rate? Standard contributions amount to 12% of basic wages plus dearness allowance from both employer and employee. The employer's contribution divides into 8.33% for the pension fund and the remainder for the Provident Fund account. When can employees withdraw from EPF? Full withdrawal becomes available at retirement, while partial withdrawals are permitted for specific needs such as housing purchases, education funding, medical emergencies, and during officially declared natural disasters or pandemics. Is EPF transferable between jobs? Yes, employees can seamlessly transfer their EPF accounts when changing employers through a streamlined online process. ensuring continuous accumulation of retirement benefits throughout their career trajectory. How is interest calculated on EPF? Interest accrues on a monthly running balance basis at rates determined annually by the central government in consultation with the Central Board of Trustees. This rate is typically higher than standard savings accounts to encourage long-term retirement planning. What happens if my employer doesn't deposit contributions? Non-compliant employers face serious consequences, including recovery proceedings, substantial interest penalties, 12% per annum, damage assessments, and potential imprisonment for severe or persistent violations. Can self-employed people join EPF? Currently, the EPF scheme remains exclusively designed for employer-employee relationships, making self-employed individuals ineligible. However, alternative retirement instruments like the National Pension System (NPS) offer comparable benefits for self-employed persons. Is EPF taxable? EPF contributions and accrued interest enjoy tax exemption up to prescribed limits under Section 80C of the Income Tax Act. However, withdrawals made before completing 5 years of continuous service become taxable unless they meet specific exemption criteria. For comprehensive information covering additional topics such as advance withdrawal conditions, nomination procedures, and dispute resolution mechanisms, please consult the detailed EPF handbook provided separately. Employee state insurance provisions. The Employee State Insurance (ESI) scheme is a comprehensive Social Security program applying to establishments with 10-plus employees, with special provisions for hazardous occupations, funded by employer, 3.25%, and employee, 0.75% contributions. It provides medical benefits, sickness compensation, maternity support, and disability coverage through a nationwide network of healthcare facilities. Basic applicability. Chapter 4 on Employee State Insurance Corporation applies to establishments with 10 or more employees, excluding seasonal factories. This includes permanent and contractual workers in factories, hotels, restaurants, cinemas, road transport, and newspaper establishments. Hazardous occupations. Establishments involved in hazardous or life-threatening operations as notified by the central government are covered even if they employ only one person. Such occupations include mining, chemical manufacturing, high-risk construction sites, and facilities handling radioactive materials. Plantations. Plantation employers may opt into Chapter 4 by expressing willingness to the corporation, provided the benefits exceed their current offerings. Eligible plantations include tea, coffee, rubber, and similar agricultural enterprises with significant labor forces. Extended coverage. The central government, in consultation with the corporation and with 6 months' notice, may extend provisions to any establishment Class 4 industrial, commercial, or agricultural. Many state governments have already expanded coverage to include shops, hotels, and educational institutions. Employer and employee contributions become payable from the date the central government notifies benefits under Chapter 4. These contributions fund medical facilities, cash benefits, and administrative expenses for the self-financing Social Security scheme nationwide. Implementation occurs through a network of regional and local offices, medical institutions, and dispensaries. The scheme currently operates in industrial and commercial centers across more than 843 districts in India, with phased expansion planned to achieve nationwide coverage. Frequently asked questions. What is ESI? ESI, Employee State Insurance, is a self-financing Social Security scheme providing medical benefits and cash compensation for sickness, maternity, and work injuries. Established under the ESI Act of 1948, it's administered by the Employee State Insurance Corporation as an autonomous body under the Ministry of Labor and Employment. Who contributes to ESI? Both employers, 3.25%, and employees, 0.75% contribute based on wages. Newly implemented areas may qualify for reduced rates initially to encourage compliance. What benefits does ESI provide? Benefits include comprehensive medical care, sickness benefits, maternity support, disability compensation, dependent benefits, funeral expenses, and rehabilitation allowances. Medical coverage extends to the insured person's family without expenditure limits. How do I register for ESI? Employers must register their establishment with the ESI Corporation. Employees receive an insurance number and card through this process. Registration is available online through the ESIC portal, where employers can generate temporary identification certificates for immediate medical benefit access. Are casual workers eligible for ESI? Yes, casual and temporary workers in covered establishments qualify for benefits. Eligibility applies equally to permanent, temporary, and contract employees whose monthly wages fall within the specified ceiling. Where can I access medical treatment? Treatment is available at ESI dispensaries, hospitals, and panel clinics. Emergency treatment at other facilities may qualify for reimbursement. ESIC operates over 151 hospitals and 1,489 dispensaries, with arrangements for specialized care at numerous private institutions. What if my employer fails to register? Non-registration by eligible employers is illegal and subject to penalties, including fines and possible imprisonment. Employees can report non-compliance to their nearest ESI office, which may conduct enforcement inspections. Is there a wage ceiling for coverage? Yes, employees earning up to Rs. 21,000 monthly are covered. Once covered, benefits continue even if wages exceed this ceiling, provided employment at the same establishment continues. Can I maintain ESI benefits after changing jobs? Yes, your insurance number remains valid throughout your working life. Ensure your new employer registers you under your existing insurance number if they fall under ESI coverage. What is the pension card? The pension card is a QR-coded plastic identification card issued to insured persons and their families. It streamlines access to medical benefits at ESI facilities without requiring additional documentation for each visit. The ESI Corporation continually enhances services through digital initiatives including online claim submissions, mobile benefit tracking applications, and telemedicine consultations. These advancements aim to improve accessibility and reduce administrative burdens for beneficiaries. Gratuity provisions. Gratuity is a financial benefit paid to employees after completing 5 years of continuous service. It applies to industrial and commercial establishments with 10+ employees and provides retirement security through a lump sum payment, calculated based on salary and years of service. Establishments where gratuity provisions apply. Industrial establishments, every factory, mine, oil field, plantation, port and railway company 1. Commercial establishments, every shop or establishment with 10 or more employees 2. Notified establishments, any shops or establishments officially notified by the appropriate government 3. Chapter 5 on gratuity applies to establishments where 10 or more employees are employed, or were employed, on any day of the preceding 12 months. These provisions ensure employees receive gratuity payment upon completing a specified period of service. Common questions about gratuity. What is gratuity? Gratuity is a lump sum payment made by an employer to an employee in recognition of continuous service when employment ends. It serves as a social security benefit designed to provide financial support after retirement. When is an employee eligible for gratuity? An employee becomes eligible after completing at least 5 years of continuous service with the same employer. However, in cases of death or disablement, this 5-year requirement is waived. How is gratuity calculated? The formula is last drawn salary x 1526x number of completed years of service. Salary includes basic pay plus dearness allowance but excludes bonuses, commissions, and overtime payments. Is gratuity taxable? Gratuity received by government employees is fully exempt from income tax. For non-government employees, it is exempt up to certain limits prescribed under the Income Tax Act. Can gratuity be forfeited? Yes, gratuity can be wholly or partially forfeited if services have been terminated due to any act of willful omission or negligence causing damage to the employer's property. Is gratuity payable during voluntary retirement? Yes, employees who opt for voluntary retirement or resignation after completing 5 years of continuous service are eligible for gratuity payment. What happens if the employer refuses to pay gratuity? Employees can file a complaint with a controlling authority appointed under the Payment of Gratuity Act. The authority can direct the employer to pay the amount with interest. Special cases for gratuity payment. Seasonal establishments. For employees in seasonal establishments who don't work throughout the year, gratuity is calculated proportionately based on the seasons worked. Part-time employees. Part-time employees are also eligible for gratuity if they meet the continuous service requirement. with calculations based on their actual salary. Maximum limit. The maximum gratuity amount payable is subject to a ceiling limit of 20 lakhs, as currently prescribed by the central government. A clear understanding of these provisions helps both employers and employees ensure legal compliance and enables proper financial planning for retirement or end-of-service benefits. Maternity benefit FAQs. Maternity benefits provide eligible women with 26 weeks of paid leave for first, second children and 12 weeks for subsequent births. Requirements include minimum employment period, 80 days. Benefits include job protection, nursing breaks, and special provisions for adoption, surrogacy, and pregnancy complications. Essential questions and answers about maternity benefits under the Labor Code, explained in straightforward language. Workplace coverage. All factories, mines, plantations, government establishments, and shops employing 10 or more workers must provide maternity benefits. Both public and private sector organizations meeting this employee threshold are covered. Purpose of maternity benefits: safeguard women's employment during pregnancy, provide paid leave to care for newborns, ensure financial security, support maternal health, protect child welfare, encourage women's continued participation in the workforce. Eligibility requirements: minimum employment period with current employer required at least 80 days of service within the 12 months preceding expected delivery date. Leave entitlement: 26 weeks for first or second child, 12 weeks for third or subsequent children. Up to 8 weeks can be taken before delivery, with remaining period available after childbirth. Payment calculation. Benefit equals woman's average daily wage for entire absence period, average calculated based on earnings during 3 months immediately preceding maternity leave. Special circumstances. Adoptive mothers: 12 weeks of leave for adopting a child under 3 months of age. Commissioning mothers: surrogacy: 12 weeks of leave from date of receiving the child. Miscarriage, medical termination: 6 weeks of paid leave immediately following the event. Pregnancy-related illness: up to 1 month additional paid leave with medical certification. Employment protection: prohibition against dismissal or discharge during pregnancy or maternity leave. Protection begins when employer is notified about pregnancy. Alternative duties without pay: reduction if current work could harm pregnancy. No assignment of arduous tasks or work requiring prolonged standing during advanced pregnancy. Additional benefits: 2 nursing breaks during working hours until child reaches 15 months. Breaks count as paid time and are separate from regular rest periods. Required procedures: written notification to employer about intention to take maternity leave. Specification of start and end dates. Notice ideally provided at least 8 weeks before expected delivery date. Documentation requirements: medical certificate confirming pregnancy and expected delivery date. Additional medical documentation for claims related to miscarriage, illness, or other special circumstances. These FAQs address the fundamental aspects of maternity benefits under the Labor Code. The provisions ensure that women employees receive appropriate support during pregnancy and after childbirth while safeguarding their employment rights. For questions specific to your situation, please consult your HR department or a legal professional specializing in labor laws. Employees' compensation provisions. Chapter 7 establishes a framework for compensating work-related injuries, covering accident reporting requirements, compensation calculation methods, eligibility criteria, and appeal processes. These provisions balance worker protection with clear employer responsibilities. Chapter 7, on employees' compensation, establishes a comprehensive framework for compensating workers who suffer personal injuries from accidents arising out of and during the course of employment. Frequently asked questions: what injuries are covered? Injuries resulting from workplace accidents, including occupational diseases specified in the 3rd schedule of the Code. How is compensation calculated? Compensation is determined based on the employee's monthly wage, extent of disability, and specific factors outlined in the 4th schedule of the Code. When must an accident be reported? Employers must report fatal accidents or those causing serious bodily injury within 48 hours to the designated authorities. Can compensation be denied? Yes, if the injury resulted from the employee's intoxication, deliberate disobedience, or intentional removal of safety devices. Who determines the compensation amount? The appointed commissioner determines compensation after conducting necessary inquiries and reviewing medical examinations. Is there a time limit for claiming compensation? Claims must be filed within 2 years of the accident or death, with possible extensions for legitimate delays. What happens if the employer refuses to pay? If an employer fails to pay within 1 month, the commissioner can impose interest and additional penalties on the defaulting party. Are dependents eligible for compensation? Yes, in fatal cases, eligible dependents, spouse, children, parents receive compensation according to the distribution determined by the commissioner. What medical benefits are provided? Employers must provide free first aid and necessary medical treatment, including hospitalization and specialized care when required. Can an employee appeal the compensation decision? Yes, dissatisfied employees may file an appeal with the appropriate high court within 90 days of the commissioner's order. Is interim relief available while the claim is pending? The commissioner may order partial compensation disbursement if the case is likely to be prolonged and the employee needs immediate financial support. What constitutes permanent total disablement? Injuries that permanently and completely incapacitate a worker from all forms of employment, such as loss of both hands, both feet, or complete loss of vision. These provisions ensure financial protection for employees who suffer work-related injuries and occupational diseases, creating a structured system for determining and awarding appropriate compensation. The code balances worker protection with clear guidelines for employer responsibilities. A thorough understanding of these compensation provisions benefits both employers and employees, promoting fair treatment and regulatory compliance. Regular educational initiatives and transparent implementation enhance the effectiveness of these worker welfare mechanisms. Building and other construction workers. Chapter 8 establishes comprehensive welfare measures for construction workers through a dedicated welfare board, funded by a 1 to 2% cess on construction costs. Benefits include health coverage, pensions, education assistance, and accident protection for registered workers who face hazardous conditions in the informal construction sector. Key provisions. Applicability. Chapter 8 on Social Security and cess applies to establishments engaged in building and construction work, including roads, bridges, tunnels, pipelines, and other infrastructure projects. Cess collection enables levy and collection of cess at 1 to 2% of construction cost from employers and developers to fund worker welfare programs. Welfare Board establishes dedicated Building Workers Welfare Board to administer schemes, monitor implementation, and ensure benefits reach all eligible workers. Benefits provides health coverage, education assistance, housing support, pension, insurance, and various Social Security benefits for registered construction workers and their families. These provisions ensure that building and construction workers, who often face hazardous conditions and informal work arrangements, receive adequate Social Security protection and welfare benefits throughout their careers and retirement. Frequently asked questions about building and construction workers' welfare. Common questions and answers regarding rights and benefits under Chapter 8. Who is considered a building worker? Any person working at construction sites for wages, including skilled, semi-skilled, and unskilled laborers involved in construction, alteration, repairs, maintenance, or demolition work. Is registration necessary? Yes, workers must register with the Welfare Board to access benefits. Registration requires periodic renewal as stipulated by the board. What documents are needed for registration? Identity proof, Aadhaar voter ID, age proof, work certificate from employer or labor officer, recent photographs, and bank account details for direct benefit transfer. How much cess is collected? 1 to 2% of construction cost from employers for projects above the threshold specified by the central government, with percentages varying by state regulations. What benefits do registered workers receive? Medical care, accident coverage, up to 4 lakh for permanent disability, pensions, 3,000 to 5,000 monthly after age 60, education scholarships for children, maternity benefits, 30,000 subsidized housing loans, and skill training programs. Who funds these benefits? The welfare funds come primarily from cess collected from construction projects, supplemented by government allocations and interest earned on the corpus. How are benefits claimed? By submitting applications to the Welfare Board with supporting documents through online portals or designated centers. Claims are typically processed within 30 to 45 days. Are migrant workers covered? Yes, all construction workers, including migrants, can register, with special provisions ensuring interstate portability of benefits through a unified database system. What safety equipment must employers provide? Helmets, safety belts, gloves, boots, respiratory protection, ear protection, high visibility clothing, and other protective gear specific to work hazards. Is compensation available for injuries? Yes, workers can receive medical expense coverage and disability compensation based on injury extent. Fatal accidents entitle dependents to enhanced compensation and monthly pension support. What is the employment requirement for registration? Workers must have been employed in construction for at least 90 days in the preceding 12 months. Though some states have reduced this requirement, can self-employed construction workers register? Yes, independent workers such as masons, plumbers, and electricians at construction sites can register and receive benefits. What is the registration fee? A nominal fee, typically $5,100, ensures accessibility, with fee waivers available for extremely marginalized workers. Is there an age limit for registration? Workers between 18 and 60 years can register. Those registered before 60 continue receiving benefits even after crossing the age threshold. What special provisions exist for women workers? Additional benefits include maternity assistance, creche facilities at large sites, separate sanitation facilities, and workplace harassment protection. How often is registration renewed? Typically every 2-3 years, requiring proof of at least 90 days of construction work in the previous year. What skill development opportunities are available? Registered workers can access free or subsidized training in advanced construction techniques, equipment operation, and safety protocols to enhance employability and wages. Is educational assistance provided for children? Yes, scholarships range from $3,000 to $25,000 annually based on education level, from primary school through professional courses. Are pensions available for retired workers? Yes, workers registered for at least 5 years with regular contributions receive monthly pensions after reaching age 60. Is funeral assistance provided? Yes, immediate financial assistance, $10,000 to $20,000, is provided to families for funeral expenses in case of worker death, separate from other death benefits. Unorganized workers' Social Security. Chapter 9 establishes comprehensive social security for India's 42 crore unorganized sector workers, 93% of workforce, including gig and platform workers. It provides benefits like health coverage, old age security, and disability protection through a streamlined registration system and dedicated oversight boards, marking the first formal recognition of modern work arrangements in Indian labor law. Chapter 9 on Social Security for Unorganized Workers establishes a comprehensive framework addressing the social security needs of workers in the unorganized sector, gig workers, and platform workers who have historically lacked access to formal protection systems. This landmark initiative aims to provide robust social protection to approximately 42 crore workers in India's unorganized sector, who constitute about 93% of the total workforce and form the backbone of the nation's economy. Key features. What is an unorganized worker? A person working in the unorganized sector, including home-based workers, self-employed individuals, or wage workers in the organized sector not covered by formal social security schemes. This encompasses diverse occupations such as agricultural laborers, construction workers, street vendors, domestic workers, fishermen, and numerous other workers in small enterprises with fewer than 10 employees. Who are gig and platform workers? Gig workers operate outside traditional employer-employee relationships. Platform workers connect with organizations or individuals through online platforms to solve specific problems or provide specialized services. Examples include ride-sharing drivers, food delivery personnel, freelance professionals, and others who secure short-term assignments through digital platforms. This legislation marks the first formal recognition of these modern work arrangements in India's labor laws. What benefits are provided? Comprehensive coverage including life and disability protection, health and maternity benefits, old age security, educational assistance, housing support, and additional schemes as determined by the central government. These benefits are funded through a strategic combination of contributions from the central government, state governments, and beneficiaries, with flexible funding patterns tailored to different worker categories and scheme types. How can workers register? Through a streamlined self-registration process on an accessible online portal using Aadhaar number, with alternative document provisions for those without Aadhaar. The system is designed for maximum accessibility, offering assisted registration through worker facilitation centers. Upon registration, workers receive a unique identification number enabling seamless access to benefits across different locations and employers. Are all workers eligible? Yes, the framework adopts an inclusive approach, encompassing all unorganized sector workers, gig workers, and platform workers regardless of their employment arrangements. With no income thresholds for basic eligibility, the system is truly universal in its design. Specific schemes within this framework may, however, incorporate eligibility criteria based on factors such as income level, age, or employment sector. How is implementation monitored? Dedicated national and state social security boards oversee scheme implementation and provide expert guidance on administration matters. These boards feature balanced representation from workers, employers, and government officials, ensuring diverse perspectives inform decision-making and effective monitoring of implementation progress. What about portability of benefits? The framework specifically addresses the critical need for benefit portability, ensuring workers maintain access to their entitlements regardless of geographic location or employment changes. This feature is particularly vital for migrant workers who frequently move between states or transition between different work arrangements throughout the year. How does it integrate with existing schemes? This innovative framework strategically builds upon and rationalizes existing welfare schemes while addressing critical coverage gaps. It creates a mechanism to consolidate benefits into a more coherent, accessible system for workers who previously navigated a complex landscape of disconnected schemes with varying eligibility requirements. These provisions establish a transformative framework, extending Social Security protections to all workers in the unorganized sector who have historically remained outside formal protection systems. By acknowledging the diverse and evolving nature of contemporary work arrangements, Chapter 9 represents a significant leap toward achieving universal Social Security coverage in India. This groundbreaking framework not only recognizes the substantial economic contribution of unorganized workers to the national economy, but also affirms their fundamental right to dignified working conditions and comprehensive social protection. While implementation challenges persist for including raising awareness, ensuring last-mile benefit delivery, and developing sustainable funding mechanisms for, this legislation lays a solid foundation for a more inclusive and equitable Social Security system that leaves no worker behind. Key presentation points. Emphasize the historical significance of this chapter as the first formal recognition of gig and platform workers in Indian labor law. Highlight that 93% of India's workforce, 42 crore workers, will benefit from these provisions. Key talking points. Explain the three categories of workers covered: unorganized sector workers, gig workers, and platform workers. Emphasize the comprehensive benefits package: health, maternity, disability, old age security, educational assistance, and housing support. Discuss the simplified registration process using Aadhaar and the unique ID system. Highlight the importance of benefit portability for migrant workers. Address implementation challenges if questions arise. Awareness, last mile delivery, and sustainable funding. Be prepared to discuss how this chapter compares to international best practices in Social Security for informal workers, particularly in developing economies. Employment information and monitoring. Chapter 13 establishes a nationwide system for employment facilitation and monitoring through career centers, mandatory vacancy reporting, and integrated digital platforms. This framework connects job seekers with employers while gathering crucial labor market data to inform policy decisions and educational alignment with workforce needs. Key components. Career centers, a comprehensive framework connecting job seekers with employers through counseling, skill assessment, and placement services. These centers function as one-stop solutions for employment guidance and opportunity matching. Vacancy reporting. Employers must report vacancies to designated career centers, including job requirements, skills needed, and compensation details. This promotes labor market transparency and enables systematic tracking of employment opportunities. Employment data, a robust system monitoring employment information, labor market trends, and workforce analytics. This infrastructure supports forecasting employment needs, identifying emerging sectors, and tracking nationwide formal and informal employment patterns. Digital integration, digital platforms and integrated databases that streamline job matching, skill assessment, and career development. This technological framework enhances coordination and efficiency among employment ecosystem stakeholders. Chapter 13 Framework establishes a comprehensive system for reporting vacancies, connecting job seekers with employers, and monitoring employment trends. Aims to improve labor market efficiency, reduce unemployment periods, enhance workforce productivity, and deliver better employment services across sectors and skill levels, creates a network of career counseling centers that match jobs while providing guidance on skill development, career progression, and entrepreneurship opportunities, ensures these centers collaborate with educational institutions and training providers to align education outcomes with labor market demands, generates quarterly employment reports that are publicly available, increasing transparency and enabling researchers, policymakers, and educational institutions to make informed decisions based on current labor market conditions. Frequently asked questions. Key questions include, how do I register with a career center? Register online through the portal or visit any designated center with your ID and qualification documents. Registration is free and provides access to job listings, career counseling, and personalized skill development programs. Are employers required to hire through career centers? No, reporting vacancies is mandatory, but employers can hire through any channel. The requirement aims to maintain accurate employment data rather than restricting hiring methods. Many employers value the time saved by accessing pre-screened candidates. How is employment data used? Data helps identify job market trends, skill gaps, and informs better employment policies and training programs. It also reveals regional employment disparities, sector-specific challenges, and guides targeted interventions for vulnerable worker groups. What benefits do career centers offer job seekers? Centers provide personalized career guidance, skill assessment, training recommendations, resume assistance, interview preparation, and employer connections. They also offer information about government schemes and financial support for skill enhancement. How frequently must employers report vacancies? Employers must report all new vacancies within 15 days of creation. For large-scale or seasonal hiring, advance notification helps career centers prepare suitable candidates. Is there support for entrepreneurs and self-employment? Yes, career centers provide guidance on self-employment opportunities, basic entrepreneurship training, information about startup funding, and connections to mentorship programs for aspiring entrepreneurs. Social Security organizations. The Code establishes two primary Social Security bodies: the Central Board of Trustees, administering employees' provident fund, and the Employees State Insurance Corporation, managing health insurance. These organizations, along with state boards, standing committees, and medical benefit councils, form India's institutional framework for delivering Social Security benefits to workers. Central Board of Trustees. The central government constitutes the Central Board of Trustees to administer the Employees' Provident Fund under Chapter 3 and related provisions of the Code. The Central Board functions as a body corporate with perpetual succession and a common seal, with the legal authority to sue and be sued, comprising a chairperson, vice chairperson, and members representing employers, employees, and the government. The board manages the EPF scheme, invests funds prudently, and ensures timely disbursement of benefits to members. Employees State Insurance Corporation. The central government establishes the Employees State Insurance Corporation (ESIC) to implement Chapter 4 and related provisions of the Code. Like the Central Board, ESIC operates as a body corporate with perpetual succession and a common seal, with full legal standing. Chaired by the Union Minister of Labor, ESIC includes representatives from central and state governments, employers, employees, and medical professionals. It oversees the comprehensive health insurance and medical benefit system for workers nationwide. The Code establishes these specialized organizations to administer distinct aspects of Social Security. Each body is responsible for implementing schemes, collecting contributions efficiently, and ensuring benefits reach eligible workers under their respective jurisdictions. Additional Social Security bodies. State Boards. 1. State governments establish these boards to implement Social Security schemes locally, coordinate with central authorities, and address region-specific labor concerns effectively. Standing Committee. 2. This executive subcommittee of the Central Board manages day-to-day administration and develops policy recommendations for the board's consideration and approval. Medical Benefit Council. 3. This specialized body advises ESIC on medical benefit delivery, healthcare administration standards, and streamlining certification procedures for insured workers. Common FAQs. The following are frequently asked questions. What is the primary function of the Central Board? To administer the Employees' Provident Fund schemes and oversee implementation of provisions under Chapter 3 of the Code. What is the legal status of these organizations? Both function as bodies corporate with perpetual succession and common seals, possessing full legal capacity to enter agreements, own property, and engage in litigation. Who establishes these Social Security organizations? The central government constitutes both organizations through official notification in accordance with the code's provisions. How often do these bodies meet? The Central Board typically convenes quarterly, while ESIC meets at minimum once every 6 months to evaluate operations and formulate policy directives. Can these organizations create subcommittees? Yes, both bodies have authority to establish specialized subcommittees for functions such as investment oversight, benefit administration, and grievance resolution. How are members appointed to these organizations? The central government appoints members according to specific representation requirements outlined in the code, ensuring balanced participation from all stakeholders including employers, employees, and government representatives. National Social Security Board. The National Social Security Board is the apex body established under the Social Security Code, 2020 to address the welfare needs of unorganized workers. Chaired by the Union Minister for Labor and Employment, this 42-member board recommends schemes, monitors implementation, and coordinates with stakeholders to ensure Social Security benefits reach over 90% of India's workforce. Key information. Constitution. The central government shall constitute a National Social Security Board for unorganized workers to exercise powers and perform functions assigned under this code. The board is established under Section 6 of the Social Security Code, 2020. Composition. The board shall be chaired by the Union Minister for Labor and Employment, with the Secretary of the Ministry as vice chairperson, and include 40 nominated members representing various stakeholders including unorganized workers, employers, state governments, parliamentarians, and experts in the field of Social Security. Term. Members nominated to the National Social Security Board shall hold office for a period of 3 years. The central government may remove any member before the expiry of their term under specific circumstances defined in the code. Meetings. The board shall meet at least 3 times a year, with the chairperson deciding the time, date, and place of the meeting. The quorum for meetings shall be 1/3 of the total members, and decisions shall be taken by majority vote. Core functions of the National Social Security Board. Recommend suitable schemes. Develop and recommend appropriate Social Security schemes for different categories of unorganized workers based on their specific needs and vulnerabilities. 1. Advise government. Provide expert guidance to the central government on administration of the Social Security Code and implementation challenges for unorganized sector. 2. Monitor implementation, track the execution of welfare schemes, evaluate their effectiveness, and ensure benefits reach intended beneficiaries across the country. 3. Review expenditure, oversee the allocation and utilization of funds for various welfare schemes to ensure financial accountability and optimal resource use. 4. The National Social Security Board serves as the apex body for addressing the Social Security needs of unorganized workers, ensuring that appropriate schemes and benefits reach this vulnerable section of the workforce. The board plays a crucial role in bridging the gap between policy formulation and implementation, particularly for workers who have historically remained outside the formal Social Security framework. The board coordinates with various ministries, state governments, and other stakeholders to create a comprehensive safety net for unorganized workers, who constitute over 90% of India's workforce. Through its recommendations and oversight, the board aims to address challenges such as lack of formal employer-employee relationships, seasonal employment, and migrant work conditions. Frequently asked questions. Who is considered an unorganized worker? An unorganized worker is any person who works in the unorganized sector and is not covered under the Employee Provident Fund or employee state insurance schemes, including self-employed workers, home-based workers, wage workers, and gig workers. 1. How do workers register for Social Security benefits? Workers can register through the ESHRM portal by providing basic personal and occupational details along with Aadhaar number and bank account information. Registration can also be done through Common Service Centers, CSCs, or with the assistance of Worker Facilitation Centers. 2. What benefits are available to unorganized workers? Benefits include health and maternity benefits, disability cover, old age protection, education for children, housing assistance, funeral assistance, skill development opportunities, and access to credit facilities depending on specific schemes implemented. 3. How does the National Board ensure scheme implementation? The board monitors implementation through regular reviews, data collection, stakeholder feedback, coordination with state-level boards, impact assessment studies, and periodic audits of scheme performance and fund utilization. 4. Can seasonal or migrant workers access these benefits? Yes, seasonal and migrant workers are eligible for benefits under various schemes once registered with proper identification and documentation. Special provisions are made to ensure portability of benefits across state boundaries. 5. What is the relationship between national and state boards? The national board provides policy framework and guidelines, while state boards implement schemes at the ground level. There is a coordinated approach with regular consultation between national and state bodies to ensure consistency and effectiveness. 6. How is the funding for unorganized worker schemes managed? Funding comes from multiple sources including central government allocations, state government contributions, employer contributions where applicable, and worker contributions in certain schemes. The board oversees proper utilization of these funds. 7. What role does the board play in emergencies like COVID-19? During emergencies, the board recommends special relief measures, coordinates implementation of emergency assistance, and adapts existing schemes to address immediate needs of vulnerable workers affected by the crisis. 8. The National Social Security Board works in close collaboration with various government departments, civil society organizations, and worker representatives to ensure that Social Security reaches the last mile. Its inclusive approach ensures that the diverse needs of different categories of unorganized workers are addressed through tailored solutions. State Unorganized Workers Board. The State Unorganized Workers Board is a statutory body established by each state government to implement Social Security measures for unorganized workers. Chaired by the state labor minister, these boards recommend and monitor welfare schemes, manage funding, and ensure benefits reach workers across various unorganized sectors. Key information. Constitution. Every state government shall constitute a state unorganized workers' Social Security Board as mandated under Section 6 of the Unorganized Workers' Social Security Act, 2008. Composition. The board is chaired by the State Minister of Labor and Employment, with the Principal Secretary Labor serving as vice chairperson. It includes 31 nominated members representing various stakeholders including workers, employers, and Social Security experts. Term. Board members serve for 3 years from the date of notification in the Official Gazette, with eligibility for renomination for a maximum of 2 consecutive terms. Functions. The board recommends suitable schemes for different categories of unorganized workers, advises the state government on policy matters, monitors welfare scheme implementation, reviews record-keeping functions, and oversees expenditure from the state Social Security Fund. Meetings. The state board meets at least quarterly and may form specialized subcommittees to address specific issues related to different categories of unorganized workers within the state. Funding. The board oversees the state Social Security Fund, which receives contributions from the state government, employers, and registered workers as prescribed by specific state-implemented schemes. The State Unorganized Workers Board works in conjunction with the National Board to implement Social Security measures at the state level, ensuring unorganized workers receive appropriate benefits and protection. Each state can customize schemes based on regional requirements while maintaining alignment with national guidelines and objectives. Frequently asked questions. Who qualifies as an unorganized worker? Any worker in the unorganized sector, home-based worker, self-employed worker, or wage worker in the organized sector who is not covered by formal arrangements such as the Employees Provident Fund or Employees State Insurance Schemes. How do workers register with the State Board? Workers can register by submitting a simple application with basic identity proof at the nearest registration center or through the State Board's online portal. Registration typically requires Aadhaar details, bank account information, and basic occupational information. What benefits are available to registered workers? Registered workers gain access to health insurance, accident coverage, maternity benefits, old age protection, educational assistance for children, housing subsidies, and additional welfare schemes approved by the State Board in consultation with the National Board. How frequently does the State Board convene? The State Board meets quarterly at minimum, with provisions for special sessions to address urgent matters concerning worker welfare or implementation challenges. How do state-level schemes differ from national initiatives? State-level schemes address region-specific challenges and occupational hazards relevant to the local workforce while complementing national programs. States may offer additional benefits or modified implementation mechanisms suited to local conditions. Can workers access benefits across different states? With the implementation of portable benefits through the ESHRM portal, registered workers can increasingly access certain benefits across state boundaries, though some state-specific schemes may have residency requirements. What role do workers' representatives play on the board? Workers' representatives ensure that the actual needs and challenges faced by various categories of unorganized workers inform policy formulation and scheme implementation, bringing essential grassroots perspective to the board's decisions. The state board adapts national social security frameworks to state-specific contexts, addressing the diverse needs of unorganized workers across sectors including agriculture, construction, domestic work, and traditional crafts. Through close coordination with local administrative bodies, the board ensures effective last-mile delivery of benefits to eligible workers. The Building Workers Welfare Board is established by state governments to provide social security and welfare benefits to construction workers. It manages a welfare fund financed through cess collection, offering benefits like accident coverage, medical assistance, educational support, pension, and housing assistance to registered construction workers aged 1860.
Building Workers Welfare Board. Key aspects of the Building Workers Welfare Board. Constitution. Every state government establishes a Building and Other Construction Workers Welfare Board to implement and oversee welfare measures for construction workers throughout the state. Composition. The board comprises a state government-nominated chairperson, one central government nominee, and up to 15 members representing workers, employers, and state government officials, ensuring balanced stakeholder representation. Fund administration. The board manages the Building and Other Construction Workers Welfare Fund, which accumulates through cess collection from construction projects and funds worker welfare schemes and administrative expenses. Welfare functions. The board provides comprehensive benefits including death and disability compensation, pension, educational assistance, medical expense coverage, maternity benefits, housing support, skill development, and disaster relief. The Building Workers Welfare Board serves as a critical safety net for construction workers who frequently face hazardous conditions without formal employment arrangements. Over 50 million workers are engaged in building and construction activities across India, representing one of the largest segments of the unorganized workforce. The board ensures these vulnerable workers receive essential social security protections typically unavailable through employer benefits or formal systems. Frequently asked questions. Who can register with the Building Workers Welfare Board? Workers aged 1860 who have completed at least 90 days of construction work in the previous 12 months are eligible for registration. This includes masons, carpenters, painters, plumbers, electricians, and other skilled and unskilled construction workers. What documents are needed for registration? Required documents include age proof, birth certificate, school certificate, or Aadhaar card, address verification, ration card, voter ID, or utility bill, bank account details, passport size photographs, and evidence of 90 days construction work, employer certificate or union authenticated work diary. How much is the registration fee? Registration fees are intentionally minimal to encourage widespread participation, typically ranging from 50 rupees 100 for initial registration and 25 rupees 50 for annual renewal, with specific amounts varying by state. What benefits can workers get from the board? Benefits include accident coverage, up to 4 rupees lakh for total disability, medical assistance, hospitalization reimbursement, educational support for children's scholarships from primary to professional courses, retirement pension, monthly payments after age 60, maternity benefits, financial assistance and paid leave, and subsidized housing loans. How is the welfare fund created? The fund is financed through a mandatory cess of 1-2% collected on construction projects above a specified cost threshold. This cess is transferred to the welfare board for distribution as worker benefits. How often do workers need to renew their registration? Workers must renew their registration annually by paying the renewal fee and demonstrating at least 90 days of construction employment during the previous year. Some states now offer online renewal systems for greater convenience. Can family members receive benefits if a registered worker dies? Yes. Families of registered workers are entitled to death benefits including a lump sum payment, typically 2 rupees 5 lakh, and monthly pension for the spouse. Children may continue receiving educational benefits until completing their studies. How can workers apply for specific welfare schemes? Registered workers can apply for benefits through local board offices or labor centers by submitting appropriate application forms and supporting documents. Many states have implemented online portals to streamline this process. These FAQs address common inquiries about the Building Workers Welfare Board. For detailed information, workers should contact their local board office or visit their state labor department website. The board regularly conducts awareness camps at construction sites to educate workers about their rights and available benefits. Employees Provident Fund. The Employees Provident Fund is a mandatory retirement savings scheme where employers and employees each contribute 10-12% of wages, offering tax benefits, withdrawal flexibility, and account portability while providing financial security for retirement. The Employees Provident Fund (EPF) is one of India's largest social security schemes, providing financial security for employees during retirement or for their dependents in case of death. This compulsory contributory fund is established under Chapter 3 and is managed by the Employees Provident Fund Organization, EPFO. Contribution structure. Standard employer contribution. 10% of wages toward the Employees Provident Fund account. Standard employee contribution. 10% of wages deducted from the employee's salary. Enhanced rate. 12% contribution both employer and employee. For certain specified establishments. Key features and benefits. Financial security. Accumulates a substantial retirement corpus with attractive interest rates and government guarantee tax advantages. Contributions eligible for tax deduction under Section 80C of Income Tax Act. Flexibility. Partial withdrawals permitted for specific needs including housing, education, medical treatment, and marriage. Portability. Universal account number, UAN. System allows seamless account tracking across employers. Accessibility. Comprehensive digital platform for checking balances, submitting claims, and tracking applications. The EPF scheme primarily applies to establishments with 20 or more employees, though smaller establishments can voluntarily opt for coverage. International workers employed in covered establishments are also eligible for EPF membership, ensuring social security protection for the global workforce in India. The central government has formulated 3 main schemes under this framework: the Employees Provident Fund Scheme, Employees Pension Scheme, and Employees Deposit Linked Insurance Scheme. Together, these create a comprehensive social security system that promotes savings while providing crucial financial protection. Frequently asked questions. Provident Fund Schemes. Essential information about the 3 primary social security schemes under the code. The code establishes 3 primary social security schemes: the Employees Provident Fund Retirement Savings, Employees Pension Scheme, Pension Benefits, and Employees Deposit Linked Insurance Scheme, Life Insurance. These are administered by EPFO, feature portability through the UAN system, and include provisions for both complete and partial withdrawals under specific conditions. Key questions and answers. What is the Employees Provident Fund Scheme? A mandatory savings scheme where both employers and employees contribute 10% of wages, 12% for specified establishments, to build a retirement fund that employees can access upon retirement. What is the Employees Pension Scheme? A pension program providing financial security through various benefits including superannuation, retirement, widowers, children's, and orphan pensions after retirement or in case of permanent disability. What is the Employees Deposit Linked Insurance Scheme? A life insurance benefit that provides financial protection to families in case of an employee's death during service. The nominee receives a lump sum payment based on the employee's average provident fund balance. What funds are established under the code? The code establishes 3 distinct funds: The Provident Fund, Pension Fund, and Insurance Fund. Each is maintained separately and serves specific social security purposes under central government administration. Who administers these schemes? The Employees Provident Fund Organization, EPFO, a statutory body under the Ministry of Labor and Employment, handles day-to-day administration while the central government frames policies and oversees implementation. How do I register for these schemes? Employers must register their establishments with EPFO and enroll eligible employees. Upon enrollment, each employee receives a Universal Account Number, UAN, that remains constant throughout their career regardless of job changes. When can I withdraw from my Provident Fund? Complete withdrawal is permitted at retirement age 58, when employment ends, or after 2 months of unemployment. Partial withdrawals are allowed for specific needs such as housing, education, medical treatment, or marriage, subject to eligibility conditions. Are these schemes portable between employers? Yes. The Universal Account Number, UAN, system ensures portability throughout your career. When changing jobs between covered establishments, your PF account transfers seamlessly, maintaining continuity of your social security benefits. What happens if my employer doesn't contribute? Employer non-compliance constitutes a legal offense. Employees can file complaints with EPFO, which can conduct inspections, impose penalties, and initiate legal proceedings to recover due amounts with interest and damages. Together, these schemes form a comprehensive social security framework providing retirement benefits, pension coverage, and life insurance protection. The Code on Social Security streamlines these benefits to ensure better compliance and service delivery across all economic sectors. Employees State Insurance Corporation, ESIC, is a self-financing social security organization providing healthcare and financial assistance to workers. It offers medical benefits, cash benefits during incapacity, dependent support, and rehabilitation services. Funded by employer-employee contributions and governed by a diverse representative body. Key benefits and services. Medical benefits. Comprehensive healthcare services for insured persons and their families through an extensive network of hospitals, dispensaries, and diagnostic centers. 1. Cash benefits. Financial assistance including sickness benefit, maternity benefit, disablement benefit, and unemployment allowance during periods of incapacity or need. 2. Dependents benefit. Monthly pension payments to provide sustained financial support to dependents of deceased insured persons. 3. Medical education. Establishment of medical colleges and training institutes to enhance service quality and develop specialized healthcare professionals. 4. Rehabilitation services. Specialized physical and vocational rehabilitation programs to help injured workers regain skills and return to productive employment. 5. Chapter 4 of the Social Security Code establishes the Employees State Insurance Corporation, ESIC, to provide comprehensive medical care and financial assistance to employees during sickness, maternity, and employment injury. Operating on the principle of social insurance, this self-financing healthcare and social security system is funded through contributions from both employers and employees. ESIC maintains an extensive network of hospitals, dispensaries, and diagnostic centers nationwide to ensure accessible, quality healthcare for all insured persons. The corporation is governed by a diverse body comprising representatives from central and state governments, employers, employees, and medical professionals, ensuring balanced perspectives in policy formulation and implementation. Frequently asked questions. Who is eligible for ESIC registration? All employees earning wages up to $21,000 per month in covered establishments must register under ESIC, including both permanent and contract employees. What are the contribution rates? Employees contribute 0.75% of their wages, while employers contribute 3.25%. These mandatory contributions fund the entire spectrum of ESIC benefits. How do I access medical benefits? Simply present your ESIC card at any EC hospital or dispensary to receive free medical treatment. Your registered family members can access the same benefits using this card. What is the process for claiming sickness benefit? Obtain a medical certificate from an authorized EC doctor, complete the claim form, and submit both to your local EC office. Sickness benefit is available for up to 91 days in a single year. How long is maternity benefit provided? female insured persons can claim maternity benefit for 26 weeks for the first 2 children and 12 weeks for subsequent children, covering both pre-delivery and post-delivery periods. How do employers register with ESIC? Employers can complete the registration process online through the ESIC portal by submitting business details and employee information. Registration is mandatory for establishments employing 10 or more workers. What should I do in case of a workplace injury? Immediately report the injury to your employer. Seek treatment at an EC hospital, and ensure that an accident report with supporting medical documentation is submitted to the local ESIC office within 24 hours. Can I use ESIC benefits outside my home state? Yes. The ESIC scheme offers complete portability for insured persons can access medical benefits at any EC facility nationwide by presenting their UAN or ESIC card. Is there financial support during unemployment? Yes. The Atal Bimat Vyakti Kalyana Yojana provides unemployment assistance at 50% of wages for up to 90 days to insured persons who lose their jobs or face unemployment. The ESIC scheme stands as one of India's most extensive social security programs, currently protecting over 3.49 crore families and approximately 13.56 crore beneficiaries. The scheme continues to expand its reach and enhance service delivery through comprehensive digitization initiatives and ongoing improvements in healthcare quality and accessibility. EC Fund and Benefits. Frequently asked questions. The Employees State Insurance Scheme provides comprehensive social security benefits including medical care, sickness benefit, maternity coverage, and disability protection. Eligible employees earn up to 21,000 monthly, with employers contributing 3.25% and employees 0.75% of wages. Benefits extend to family members and include coverage for up to 6 months after leaving employment. Below are answers to common questions about the Employees State Insurance Scheme. This information covers eligibility requirements, contribution calculations, and the range of benefits available to insured persons. Who is eligible for EC benefits? Employees earning up to 21,000 per month in covered establishments qualify for EC benefits. The scheme applies to non-seasonal factories with 10 or more employees and other establishments as notified by the government. How is the EC contribution calculated? Employers contribute 3.25% and employees contribute 0.75% of monthly wages toward EC coverage. The current wage ceiling for calculation is 21,000 per month. All contributions must be remitted monthly to the EC fund. When can I claim sickness benefit? Sickness benefit becomes available after 9 months of contributions when certified by an authorized medical practitioner. Benefits are paid at approximately 70% of wages for up to 91 days in 2 consecutive benefit periods. For long-term ailments, extended sickness benefits are available. What does maternity benefit cover? Maternity benefit provides wage compensation for 26 weeks for first 2 children and comprehensive medical care throughout pregnancy. This includes prenatal care, confinement expenses, postnatal care, and a medical bonus of 7,500. How do I claim disablement benefit? First, report the employment injury to your employer, then seek medical treatment at an EC hospital, and finally submit a claim form with the required medical certificate. Temporary disablement benefit is paid at 90% of wages, while permanent disablement benefit provides a monthly pension based on loss of earning capacity. Where can I access medical services? Medical services are available at EC hospitals, dispensaries, and empaneled private healthcare providers. Services include outpatient care, specialist consultations, hospitalization, medicines, laboratory services, imaging services, and rehabilitation facilities. How long does EC coverage remain valid after leaving employment? Medical benefits continue for 6 months after leaving insured employment if you have paid at least 78 days of contributions in the preceding contribution period. Certain long-term illnesses and medical conditions qualify for extended benefit periods. What funeral expenses are covered? Up to 15,000 is payable to the eldest surviving family member of a deceased insured person to help cover funeral expenses of the deceased. Can family members also use medical benefits? Yes. Dependents of insured persons for including spouse, children, and dependent parents for are entitled to medical benefits. Children remain covered until age 25 or until they begin earning, whichever comes first. Is unemployment coverage included in EC? Yes. The Rajiv Gandhi Shramik Kalyan Yojana provides unemployment allowance at 50% of wages for up to 24 months in cases of factory closure, retrenchment, or permanent disability. To qualify, beneficiaries must have paid contributions for at least 3 years. Gratuity payment provisions. Gratuity is a mandatory retirement benefit payable after 5 years of continuous service, 3 years for journalists, calculated at 15 days wages per year of service, capped at 20 lakhs. Payment must be made within 30 days of retirement, resignation, death, or disablement, with legal protections against withholding or attachment. The Payment of Gratuity Act, 1972 establishes a mandatory gratuity payment scheme for employees working in factories, mines, oil fields, plantations, ports, railways, shops, and various other establishments. Gratuity payment structure. Eligibility. Gratuity becomes payable after completing at least 5 years of continuous service. Continuous service includes periods interrupted by sickness, accident, leave, layoff, strike, or lockout. Working journalists qualify after just 3 years of service. The 5-year requirement is waived in cases of death or disablement. Calculation. Gratuity is calculated as 15 days wages for each completed year of service or part thereof exceeding 6 months, based on the rate of wages last drawn. Formula. Monthly salary divide 26. 15 years of service. Salary components include basic pay, DNS allowance, and commission. Maximum gratuity amount is subject to government notified ceiling payment. Gratuity becomes payable upon superannuation, retirement, resignation, death, or disablement due to accident or disease. Payment must be disbursed within 30 days from the date it becomes payable. In case of death, payment is made to the nominee or legal heir for disputed claims. The employer must deposit the amount with the controlling authority. Delayed payments attract interest at specified rates. Protection. The maximum gratuity amount payable is currently capped at 20 lakhs effective the 29th of March, 2018. Gratuity cannot be attached in execution of any decree. It cannot be withheld, deducted, or forfeited except in cases of damage or loss. It receives protection from creditors during insolvency proceedings. Chapter 5 of the Act stipulates gratuity payments to employees upon employment termination after at least 5 years of continuous service. Working journalists qualify after 3 years, while the requirement is waived entirely in cases of death or disablement. Employers must calculate and disburse gratuity within 30 days from when it becomes payable. Frequently asked questions. Eligibility criteria, qualification requirements, special provisions, and exceptions to standard rules. Calculation methods. Detailed examples illustrating various employment scenarios. Tax implications. Taxation of gratuity payments under different circumstances. Payment timelines. Employer obligations and penalties for delayed payments. Special cases. Specific rules for part-time employees, contract workers, and specialized industries. For the complete frequently asked questions document, please refer to the supplementary materials. Employees seeking personalized guidance on gratuity matters may contact the HR department or Labor Welfare Office. Continuous service for gratuity. Essential guidelines. Continuous service is uninterrupted employment including authorized absences. 5 years of service is required for gratuity eligibility, with specific day requirements varying by establishment type. Gratuity is calculated at 15 days wages per year of service, with tax benefits available up to certain limits. A clear understanding of continuous service is critical for accurate gratuity calculations. Below are comprehensive answers to frequently asked questions regarding eligibility criteria and the calculation of continuous service periods. What constitutes continuous service? Continuous service refers to uninterrupted employment with a company. Notably, periods of absence due to illness, accidents, authorized leave, layoffs, strikes, or lockouts are legally recognized as part of your employment continuity rather than interruptions to service. What is the minimum tenure required for gratuity eligibility? You must complete at least 5 years of continuous service to qualify for gratuity benefits. This 5-year period is calculated from your date of joining through the date of employment termination, inclusive of any role transitions within the organization. How is continuous service defined for standard establishments? For regular establishments, you must work a minimum of 240 days in a calendar year to maintain continuous service status. This threshold is reduced to 190 days for employees working in mines or establishments operating fewer than 6 days weekly, ensuring fair treatment for various working arrangements. How does continuous service apply to seasonal employment? If employed in seasonal work, you must complete at least 75% of the operational days of the establishment during the season. This specialized provision acknowledges the inherent nature of seasonal employment while safeguarding workers' entitlements to gratuity benefits. Does transferring between affiliated companies affect service continuity? No. Service continuity remains intact when you transfer between establishments under the same employer or within affiliated group companies. The entire employment period, from initial hiring through all subsequent transfers, is considered continuous for gratuity calculation purposes. How do employment interruptions impact continuous service? Brief interruptions beyond your control do not break service continuity. However, voluntary employment gaps may reset your continuous service calculation. Judicial authorities typically evaluate the intent behind such interruptions when determining whether continuity has been maintained. How is continuous service determined for part-time employees? Part-time employees must satisfy identical criteria as full-time staff. 240 days annually for standard establishments. Importantly, each day with any working hours counts as a complete day toward this requirement, regardless of the number of hours worked. Gratuity is calculated at the rate of 15 days' wages for each completed year of service, based on your most recent salary. For precision in calculation, any month with more than 15 days is considered a complete month, and the maximum gratuity amount is subject to the ceiling prescribed by the central government. Gratuity payments enjoy tax exemption up to specific thresholds as stipulated under the Income Tax Act. This provides substantial financial advantages to long-serving employees upon retirement, resignation, or other forms of employment termination. Frequently asked questions about maternity benefits. The code provides comprehensive maternity benefits including 26 weeks of paid leave for women with fewer than 2 children, protection against dismissal, nursing breaks, child care facilities at larger workplaces, and special provisions for adoption, surrogacy, and medical situations. Eligibility requires at least 80 days of employment in the preceding 12 months. Here are common questions about maternity benefits under the code. What is maternity benefit? Paid leave provided to working women during and after pregnancy. Employees receive their normal wages during this period without deductions, ensuring financial security during maternity. How long is maternity leave? 26 weeks for women with fewer than 2 children, and 12 weeks for women with 2 or more children, providing adequate time for prenatal care and postnatal recovery. Who is eligible for maternity benefit? Women who have worked in an establishment for at least 80 days in the 12 months immediately preceding their expected delivery date. When can I start my maternity leave? Up to 8 weeks before expected delivery. 6 weeks for women with 2 or more children, with the remaining period taken after childbirth, allowing flexibility based on health needs. Do I get paid during maternity leave? Yes. You receive your normal daily wage for the entire leave period, calculated based on your average wage from the 3 months preceding your leave, including all regular allowances. What if I adopt a child? Women adopting a child below 3 months of age are entitled to 12 weeks of leave from the date the child is handed over, facilitating bonding and family adjustment. What is the benefit for a commissioning mother? Commissioning mothers, in surrogacy cases, receive 12 weeks of leave from when the child is handed over, recognizing their maternal role despite not physically giving birth. What if I have a miscarriage or medical termination? You are entitled to 6 weeks of paid leave immediately following the day of miscarriage or medical termination of pregnancy. Can I work from home after my leave ends? Where the nature of work permits and with employer agreement, work from home arrangements may be available following maternity leave, based on specific circumstances and job requirements. Does my workplace need to provide childcare? Establishments with 50 or more employees must provide creche facilities within a reasonable distance. Mothers are permitted 4 visits to the creche daily, including during rest intervals. Can I be fired for taking maternity leave? No. It is unlawful for employers to dismiss women due to maternity leave or deny entitled benefits. The law protects your employment security throughout your maternity period. Am I entitled to breaks for nursing my baby? Yes. You are entitled to nursing breaks until your child reaches 15 months of age. These are in addition to regular rest intervals and count as paid time. Do I need to give notice before taking maternity leave? Yes. Written notice should be provided to your employer at least 7 weeks before your expected delivery date, stating when you intend to begin leave and including proof of pregnancy. What if I have a tubectomy operation? Women undergoing tubectomy operations are entitled to 2 weeks of paid leave immediately following the procedure, allowing for proper recovery. These FAQs cover the fundamental aspects of maternity benefits under the code. For specific situations or complex cases, please consult your HR department or a legal advisor. Frequently asked questions about maternity benefits. The code provides comprehensive maternity benefits including 26 weeks of paid leave for women with fewer than 2 children, protection against dismissal, nursing breaks, child care facilities at larger workplaces, and special provisions for adoption, surrogacy, and medical situations. Eligibility requires at least 80 days of employment in the preceding 12 months. Here are common questions about maternity benefits under the code. What is maternity benefit? Paid leave provided to working women during and after pregnancy. Employees receive their normal wages during this period without deductions, ensuring financial security during maternity. How long is maternity leave? 26 weeks for women with fewer than 2 children, and 12 weeks for women with 2 or more children, providing adequate time for prenatal care and postnatal recovery. Who is eligible for maternity benefit? Women who have worked in an establishment for at least 80 days in the 12 months immediately preceding their expected delivery date. When can I start my maternity leave? Up to 8 weeks before expected delivery, 6 weeks for women with 2 or more children, with the remaining period taken after childbirth, allowing flexibility based on health needs. Do I get paid during maternity leave? Yes. You receive your normal daily wage for the entire leave period, calculated based on your average wage from the 3 months preceding your leave, including all regular allowances. What if I adopt a child? Women adopting a child below 3 months of age are entitled to 12 weeks of leave from the date the child is handed over, facilitating bonding and family adjustment. What is the benefit for a commissioning mother? Commissioning mothers, in surrogacy cases, receive 12 weeks of leave from when the child is handed over, recognizing their maternal role despite not physically giving birth. What if I have a miscarriage or medical termination? You are entitled to 6 weeks of paid leave immediately following the day of miscarriage or medical termination of pregnancy. Can I work from home after my leave ends? Where the nature of work permits and with employer agreement, work from home arrangements may be available following maternity leave, based on specific circumstances and job requirements. Does my workplace need to provide childcare? Establishments with 50 or more employees must provide creche facilities within a reasonable distance. Mothers are permitted 4 visits to the creche daily, including during rest intervals. Can I be fired for taking maternity leave? No. It is unlawful for employers to dismiss women due to maternity leave or deny entitled benefits. The law protects your employment security throughout your maternity period. Am I entitled to breaks for nursing my baby? Yes. You are entitled to nursing breaks until your child reaches 15 months of age. These are in addition to regular rest intervals and count as paid time. Do I need to give notice before taking maternity leave? Yes. Written notice should be provided to your employer at least 7 weeks before your expected delivery date, stating when you intend to begin leave and including proof of pregnancy. What if I have a tubectomy operation? Women undergoing tubectomy operations are entitled to 2 weeks of paid leave immediately following the procedure, allowing for proper recovery. These FAQs cover the fundamental aspects of maternity benefits under the code. For specific situations or complex cases, please consult your HR department or a legal advisor. Employees' compensation for injuries. Frequently asked questions. Employee compensation provides financial protection for work-related injuries and illnesses. Eligibility depends on how the injury occurred, with specific calculation methods based on wages and injury type. Claims must be filed within specified time frames, and employees are protected from retaliation for filing legitimate claims. Here are common questions about employee compensation for workplace injuries under the code. What is employee compensation? It is financial protection provided to workers who suffer injury or occupational illness in the course of employment. Employers are legally obligated to provide this compensation when work-related accidents occur. When must employers pay compensation? Compensation is payable when employees sustain injuries from accidents arising out of and during the course of employment, or when they develop occupational diseases directly attributed to their work environment or duties. Do employers always have to pay for injuries? No. Employers may be exempt from liability when the injury results in incapacity lasting less than 3 days, the worker was under the influence of alcohol or drugs, or the employee willfully disregarded explicit safety instructions. Can workers get compensation if they violated workplace rules? Yes. Generally, compensation remains payable if the employee was still performing duties within the scope of employment. Mere negligence or rule violation does not disqualify a worker unless it constitutes willful disobedience of specific safety orders. How is the compensation amount calculated? Compensation is calculated based on the employee's monthly wages, age, using a relevant factor from the compensation tables, and the nature and extent of injury. Different formulas apply for cases involving death, permanent disability, and temporary disability. What should I do if I'm injured at work? Immediately notify your supervisor or employer about the incident. Seek appropriate medical attention, and inquire about the procedure for filing a compensation claim. Maintain comprehensive records of all medical consultations, treatments, and related expenses. How long do I have to file a claim? You must report the accident to your employer within 24 hours. For formal claims, you generally have 2 years from the date of injury or from when you reasonably discovered that your illness was work-related. Can I choose my own doctor for treatment? This depends on your employer's insurance arrangements and local regulations. Initially, you may need to consult with employer-designated healthcare providers, but provisions exist for requesting alternative medical practitioners after the initial assessment. What benefits are covered under compensation? Compensation typically encompasses medical treatment expenses, disability benefits both temporary and permanent, vocational rehabilitation services, and death benefits for eligible dependents in case of fatal workplace accidents. Can I be terminated for filing a compensation claim? No. The law explicitly prohibits retaliatory termination or discrimination against employees for filing legitimate compensation claims. Such actions by employers are unlawful and subject to additional penalties. These FAQs address fundamental aspects of employee compensation under the code. For specific situations or complex cases involving workplace injuries, consult with your HR department, the appropriate government authority, or a legal professional specializing in labor law. Compensation amounts. Frequently asked questions. The code establishes 3 main compensation categories. Death benefits 50% of monthly wages, permanent disability 60% of monthly wages, and temporary disability 25% of monthly wages. Compensation calculations incorporate age factors, with additional provisions for medical expenses and rehabilitation. This guide answers common questions about compensation under the code, addressing how amounts are calculated, who is eligible, and important deadlines. These FAQs cover the most important aspects of workplace injury compensation for both employees and employers. Death compensation FAQs. How is death compensation calculated? 50% of monthly wages multiplied by the relevant age-based factor of the deceased employee. Who receives death compensation? Dependents of the deceased employee is defined in the code. Is there a minimum amount? Yes. The code guarantees a minimum compensation regardless of wage level. What's the deadline for filing claims? Within 2 years from the date of death or knowledge of death. Are funeral expenses covered? Yes. A separate fixed amount is provided specifically for funeral costs. Can pre-existing conditions affect compensation? No, if the workplace accident contributed to or accelerated the death. Permanent disability FAQs. What constitutes permanent total disablement? Injuries that permanently prevent an employee from performing work they could do before the accident. How is permanent disability compensation calculated? 60% of monthly wages multiplied by the relevant age-based factor. How is partial disability compensation determined? As a percentage of total disability compensation based on the degree of disability. Does the code specify compensation for specific injuries? Yes. A comprehensive schedule lists disability percentages for specific body parts. Are rehabilitation benefits available? Yes. Vocational rehabilitation may supplement monetary compensation. Is compensation taxable? No. Disability compensation under the code is generally exempt from income tax. Temporary disability FAQs. When do temporary disability payments begin? After a 3-day waiting period from the injury date. How long can these payments continue? For the duration of disablement or up to the maximum period specified in the code. What amount is provided? 25% of monthly wages, paid half monthly. Can employers terminate employees on temporary disability? No. The code protects employees from termination during temporary disability periods. What if an employee can work with restrictions? Partial temporary disability benefits may apply if the employee returns with reduced earning capacity. Is medical certification needed? Yes. Continuing benefits require periodic medical certification. General compensation FAQs. What is the relevant factor? An age-based multiplier used in compensation calculations. Are medical expenses covered? Yes. Employers must provide medical care in addition to compensation. How are monthly wages calculated? Based on the average wage during the 12 months before the injury. Is compensation available for occupational diseases? Yes. The code lists specific eligible occupational diseases. How can compensation amounts be disputed? Disputes may be referred to the Commissioner for Workmen's Compensation. Are temporary and contract workers eligible? Yes. The definition of employee includes various employment arrangements. When might employers be exempt from liability? Only in limited cases like willful disobedience of safety rules or intoxication. The code provides comprehensive guidelines for calculating compensation based on injury severity and type. Consult the complete compensation tables in the code for specific calculations based on age, wages, and injury. Employers must maintain adequate insurance coverage to ensure prompt compensation payment. The code also establishes clear procedures for accident reporting, claim filing, and dispute resolution. Workers should understand these provisions to secure their rightful benefits following workplace injuries. Building Workers' Welfare Cess. A mandatory 1-2% cess on construction costs that funds social security and welfare measures for building workers. The collected funds support pension benefits, death and disability compensation, medical expenses, educational schemes, and other welfare initiatives through the Building Workers Welfare Board. Chapter 8 establishes a mandatory cess on construction costs incurred by employers. This cess ranges from 1-2% of the total construction cost and funds crucial social security and welfare measures. Funding is administered through the Building Workers Welfare Board. This funding mechanism provides essential financial support for construction workers who face hazardous conditions and limited job security. As illustrated in the chart, the allocation prioritizes long-term security through pension benefits 30%, immediate safety nets via death and disability benefits 25%, ensuring comprehensive protection for workers' collection and administration. The local authority or state government collects this cess and transfers it to the Building Workers Welfare Board. The board administers funds according to code guidelines. Every qualifying construction project must register and contribute, creating a sustainable funding stream. This ensures ongoing welfare initiatives that benefit this vulnerable workforce. Frequently asked questions FAQs. What is Building Workers Welfare Cess? A dedicated tax collected from construction projects funds welfare schemes for construction workers, represents a social responsibility mechanism ensuring that development activities benefit those who make these projects possible. Who pays this? Cess, all construction employers including government departments, public sector undertakings, local authorities, private contractors whose projects exceed the threshold value specified in the code. How much is the cess rate? Between 1-2% of the total construction cost. Exact percentages determined by state government notifications. The calculation excludes land costs and compensation paid for land acquisition. What benefits do workers get? A comprehensive package including pension, medical care, disability benefits, and death compensation, educational support for children. Additional benefits include maternity support, housing assistance, skill development programs, and natural calamity relief. How can workers access these benefits? By registering with the Building Workers Welfare Board, submitting scheme-specific applications. Registration requires employment verification in the construction sector, age proof, and other prescribed documentation. Periodic renewal to maintain eligibility. Implementation challenges. Despite providing a robust welfare framework, implementation faces significant hurdles. Ensuring complete worker registration, preventing fund distribution leakage, raising awareness about available benefits, maintaining accurate employment records in an industry characterized by high mobility and informal work arrangements. The code addresses these challenges through digital registration systems, streamlined application procedures, collaborative efforts between employers, workers' organizations, and government agencies. These efforts enhance coverage and improve benefit delivery efficiency. Building workers aged 1860 with 90+ days of construction work annually can register for welfare benefits including healthcare, education support, and pension. Registration requires identity verification and employer certification, with annual renewal to maintain eligibility. The system ensures proper identification of beneficiaries and efficient distribution of welfare measures. Building workers registration. Registration process. Eligibility check. Workers must be 1860 years old, must have completed 90+ days of construction work in the past 12 months. Documentation. Submit ID proof, age verification, address documents, bank details, photos, work certification. Application submission. Apply to authorized officer of the Building Workers Welfare Board. Annual renewal. Maintain eligibility by proving 90+ days of construction work each year. Registration process overview. Eligibility. Building workers aged 1860 who have completed at least 90 days of construction work in the preceding 12 months. This includes masons, carpenters, painters, plumbers, electricians, and unskilled laborers at construction sites. Registration process. Workers must submit an application to an officer authorized by the Building Workers Welfare Board with identity proof, age verification, address documentation, bank account details, recent photographs, and certification of 90 days of construction work from an employer or local authority. Registration typically requires annual renewal. Cessation. Beneficiary status ends upon reaching age 60 or when a worker is not engaged in building work for at least 90 days in a year. Workers must report any changes in employment status or permanent departure from the construction sector. Failure to renew registration also terminates benefits. Extended benefits. Workers with at least 3 consecutive years of registration before turning 60 remain eligible for specific benefits including pension, healthcare for chronic conditions, and access to skill upgradation programs for alternative livelihoods. Their family members may continue to receive educational scholarships and healthcare benefits. The code establishes a comprehensive registration system enabling building workers to access welfare benefits through the Building Workers Welfare Fund. This mechanism ensures accurate identification of eligible beneficiaries and facilitates efficient distribution of welfare measures across the construction sector, which employs millions of workers often in vulnerable conditions. Frequently asked questions. How do I register as a building worker? Apply to the Welfare Board through an authorized officer. Provide proof of age, 90 days of construction work, and other required documents. Application forms available at local labor offices or official website. Required documents include Aadhaar card, bank passbook copy, and employment certification. What benefits do I get after registration? Medical care, up to $50,000 annually. Educational support for children. Scholarships of 3,00015 $0.000 per child annually, pension benefits, disability coverage, maternity benefits for female workers, funeral assistance of $10,000 for natural death, other welfare measures from the Building Workers Welfare Fund. Do I need to renew my registration? Yes. Annual renewal required, proof of 90 days of construction work each year needed, submit simplified renewal form with employment certificate, submit at least 30 days before current registration expires to maintain continuity of benefits. What happens when I turn 60 years old? Regular benefits cease at age 60. Workers registered continuously for at least 3 years prior remain eligible for monthly pension. 1,003,000 depending on contribution period. Continued healthcare benefits, access to senior citizen welfare programs administered by the board. Can I register if I work at multiple construction sites? Yes. Workers at multiple sites or with multiple employers can register, obtain certificates from each employer or a consolidated certificate from local workers union authority. Certificate must confirm completion of 90 days of construction work in preceding 12 months. What if I relocate to another state for work? Apply for registration, transfer to the board in your new state. Some states have reciprocal arrangements recognizing registration from other states, others require new registration. Always notify your current board about relocation. Ensures proper transfer of contribution history and continued benefit eligibility. The code establishes comprehensive welfare schemes for unorganized workers through central and state government initiatives, providing insurance, healthcare, old age protection, and other benefits through diverse funding mechanisms to extend social security to this vulnerable majority of India's workforce. Unorganized worker schemes. Central government schemes. The central government formulates comprehensive welfare schemes for unorganized workers covering life and disability insurance, health and maternity benefits, old age protection, education, and additional support services. Key initiatives include the Pradhan Mantri Jeevan Jyoti Bima Yojana for life insurance, Pradhan Mantri Suraksha Bima Yojana for accident coverage, and Ayushman Bharat for essential healthcare services. State government schemes. State governments implement complementary schemes addressing provident fund provisions, employment injury benefits, housing assistance, educational support for children, skill enhancement, funeral assistance, and old age homes. Various states have developed region-specific programs to address local challenges, including affordable housing projects, mobile healthcare units, and specialized skill development centers aligned with regional industries. Funding mechanisms. These welfare schemes operate through diverse funding structures. Some are entirely government funded, others utilize a mixed model with both government and worker contributions, while some leverage alternative funding sources including corporate social responsibility (CSR) initiatives. The code facilitates strategic public-private partnerships and innovative community-based funding models to ensure long-term sustainability and comprehensive coverage. Chapter 9 establishes a robust framework for extending social security to unorganized workers, who represent the majority of India's workforce yet traditionally lack access to formal protection systems. These provisions specifically address the vulnerabilities unique to this sector while accommodating the diverse nature of unorganized work across both urban and rural contexts, marking a significant advancement toward universal social security coverage.
Frequently asked questions. Who are unorganized workers? Unorganized workers include those employed in the unorganized sector, home-based workers, self-employed individuals, and wage workers in the organized sector who lack social security benefits. This encompasses street vendors, domestic workers, agricultural laborers, construction workers, and others working without formal employment contracts. How can workers register for these schemes? Registration is available through designated government authorities at the local level, common service centers, mobile applications, and periodic registration camps. Workers need only provide basic identification and occupational information to obtain a social security number that enables access to multiple benefit programs. Are these schemes free for workers? While some schemes are fully government-funded, others require minimal worker contributions. The contribution structure features subsidized rates for low-income workers and often includes enhanced benefits for consistent contributors, incentivizing sustained participation in the Social Security system. Can seasonal workers benefit from these schemes? Yes, the code includes specific provisions for seasonal and migrant workers, ensuring benefit continuity during non-working periods through relaxed eligibility criteria that accommodate the intermittent nature of seasonal employment. How are the benefits distributed to workers? Benefits are primarily delivered through direct transfers to bank accounts linked to workers' identification numbers. For the unbanked population, alternative distribution channels include mobile money services and post office disbursements. Effective implementation of these schemes relies on efficient administration, worker awareness programs, and streamlined processes. The government conducts targeted outreach initiatives to educate unorganized workers about their entitlements and provide assistance with the registration process. Gig and platform workers. The code extends Social Security protections to digital economy workers, recognizing gig workers, freelancers outside traditional employment, and platform workers engaged through online intermediaries. It establishes innovative funding mechanisms through aggregator contributions to support specialized benefits schemes. Groundbreaking provisions. The code introduces landmark advancements in labor legislation that respond to new work formats driven by technological innovation, extending vital Social Security protections to emerging categories of workers in the digital economy. Digital intermediaries. The code recognizes platform work as arrangements where organizations or individuals use online platforms to access others to solve specific problems or provide services. These intermediaries connect service providers with consumers, creating dynamic new marketplaces for services ranging from transportation to professional consulting. Gig workers, individuals who perform work or participate in arrangements outside traditional employer-employee relationships. This includes freelancers, independent contractors, project-based workers, and temporary hires who may work for multiple clients simultaneously, while enjoying flexibility in working hours and location. Platform workers, individuals engaged in platform work through online intermediaries. These workers utilize digital platforms to secure short-term engagements, often being paid per task or assignment rather than receiving regular wages. Examples include ride-sharing drivers, food delivery personnel, and service providers on various digital marketplaces. Social Security, specialized schemes providing life and disability cover, accident insurance, health benefits, and old age protection. The code mandates the creation of dedicated funds to support these benefits, ensuring workers in non-traditional employment relationships receive essential protections previously available only to those in formal employment. Funding mechanism. The code establishes an innovative funding approach through aggregator contributions, requiring digital platforms to contribute a percentage of their annual turnover towards Social Security schemes for workers engaged through their platforms. This creates a sustainable financial foundation for worker benefits without overburdening any single stakeholder. For comprehensive information, please refer to our detailed FAQ document addressing common questions about rights, responsibilities, and benefits for gig and platform workers under the new code. The document also outlines registration procedures, eligibility criteria, and practical mechanisms for accessing benefits under the various schemes. Aggregator contributions. Key FAQs. Digital platforms must contribute 1 to 2% of annual turnover to fund Social Security benefits for gig and platform workers, creating a sustainable safety net in the digital economy while balancing worker welfare with business viability. Essential information about the new funding mechanism for Social Security schemes benefiting gig and platform workers. What are aggregator contributions? Mandatory payments from digital platforms aggregators that fund Social Security schemes for gig and platform workers. These contributions establish a sustainable safety net specifically designed for workers in the digital economy. How much do aggregators need to contribute? Between 1 and 2% of annual turnover, not exceeding 5% of worker payments. The precise percentage varies based on platform size, worker count, and other criteria established by the appropriate government authority. Why has this been introduced? To ensure digital platforms share responsibility for worker Social Security. This addresses growing concerns about precarious working conditions while recognizing that platforms benefit from worker services without traditional employer obligations. Who benefits from these contributions? Gig and platform workers gain gain access to crucial protections including life insurance, disability coverage, accident insurance, healthcare benefits, and retirement security. Beneficiaries include delivery personnel, drivers, freelancers, and various service providers operating through digital platforms. When do these contributions take effect? Implementation begins according to central government notification. Platforms must comply within the specified time frame and establish mechanisms for regular contributions to the designated fund. How will compliance be monitored? Aggregators must submit regular contribution reports to the appropriate government authority. Non-compliance penalties include fines and potential business license suspension for repeated violations. Can platforms transfer these costs to workers or consumers? While not explicitly forbidden, regulatory authorities will vigilantly monitor pricing changes to prevent platforms from undermining social protection by reducing worker earnings or significantly increasing consumer costs. These contributions mark a significant advancement in providing social protection for digital economy workers, while establishing shared responsibility between platforms and government. The framework balances worker welfare with sustainable business operations in the rapidly evolving digital marketplace. For implementation guidelines, reporting requirements, and compliance procedures, platforms should refer to official government notifications and implementation handbooks available on the ministry's website. The code establishes a simplified registration system for unorganized, gig, and platform workers through digital and physical channels. Workers receive unique identification numbers for accessing benefits, with support available through facilitation centers, multilingual resources, and a 24/7 helpline to ensure inclusive participation. Registration of unorganized workers. The code introduces a robust registration framework for unorganized, gig, and platform workers to ensure seamless access to Social Security benefits. This user-centric system features self-registration options and digital platforms designed to simplify participation for workers across all segments of the informal economy. Registration process. The streamlined registration process eliminates unnecessary bureaucracy. Submit a simple self-declaration form online or in paper format. Provide basic documentation including Aadhaar number, file application with the appropriate authority. Obtain a personalized registration number for benefit access. Keep employment and personal information current. Complete periodic renewal, as scheduled workers needing assistance can visit dedicated worker facilitation centers established at district and block levels. Additionally, mobile registration camps are regularly deployed to locations with significant unorganized worker populations, ensuring no worker is left behind. Comprehensive resource guide. An extensive knowledge base featuring questions helps workers navigate the registration process. This guide covers detailed eligibility requirements and necessary documentation, clear, sequential application instructions, solutions to common registration challenges, procedures for claiming benefits, post-registration guidelines for registration portability when changing jobs, beneficiary nomination protocols, complaint resolution procedures. Special provisions for migrant workers. Workers can access this resource guide through the online registration portal or at any local facilitation center. To overcome language barriers, support is available in all 22 scheduled languages, ensuring inclusive access nationwide. For immediate assistance, workers can contact a dedicated 24/7 helpline, 1800XXXXX, offering real-time guidance in 10 major regional languages. This service provides crucial support for workers encountering registration difficulties. The system is deliberately designed for maximum inclusivity, addressing specific challenges faced by vulnerable worker categories in the unorganized sector. Specialized accommodations ensure workers with limited literacy, seasonal employment patterns, or residents in remote locations can fully participate in the Social Security framework established by the Code. Social Security Fund. The Code establishes central and state Social Security funds to provide unprecedented social protection for unorganized, gig, and platform workers. These funds draw from diverse revenue sources, including government allocations and aggregator contributions to finance comprehensive welfare benefits for historically unprotected worker segments. Overview. Central Social Security Fund. Established for unorganized workers, gig workers, and platform workers. Funding sources: government funding, aggregator contributions, and other sources. State Social Security Fund. Established by state governments for welfare of unorganized workers, the Code establishes a comprehensive Social Security Fund at the central level to protect unorganized workers, gig workers, and platform workers. This pioneering initiative creates a vital safety net for workers who have historically lacked access to formal social security systems. The fund functions as a centralized mechanism for collecting, managing, and dispersing resources specifically designated for worker welfare programs nationwide. Funding structure. To ensure sustainability, the fund draws from multiple revenue streams, government allocations, aggregator contributions, 1 to 2% of annual turnover based on category. CSR funds penalties collected from the composition of offenses, other government-prescribed sources. This diversified funding approach guarantees adequate resources for implementing various welfare schemes. State-level implementation. Complementing the central initiative, state governments must establish their own social security funds for unorganized workers. These state-level funds address region-specific challenges and can be customized to local employment patterns and worker demographics. This two-tier approach ensures both national consistency and local responsiveness in providing social protection. Frequently asked questions. Who can benefit from the Social Security Fund? Registered unorganized workers, gig workers, and platform workers are eligible for benefits. This includes domestic workers, construction laborers, street vendors, home-based workers, agricultural workers, and those employed through digital platforms for delivery, transportation, and other services. How is the fund financed? The fund maintains financial stability through multiple sources. Government budgetary allocations, aggregator contributions, 1 to 2% of annual turnover, corporate CSR contributions, fines collected through composition of offenses under the code, and additional government-prescribed sources. What benefits can workers get from the fund? Eligible workers can access a comprehensive range of benefits including healthcare, maternity support, accident coverage, life and disability insurance, old age pensions, education assistance for children, housing subsidies, skill development programs, funeral assistance, and other government-determined welfare measures. Benefits vary based on worker category and scheme enrollment. How can workers access these benefits? Upon registration, workers receive a unique identification number that serves as their key to all scheme benefits. They can apply through digital portals, mobile applications, or local facilitation centers. The system features simplified documentation requirements and a single-window approach for seamless benefit navigation. Is registration mandatory to access benefits? Yes, registration is a prerequisite for accessing Social Security Fund benefits. The streamlined registration process accommodates various channels including online portals, mobile applications, and local authority assistance. For many registration requirements, self-declaration is sufficient. How are benefit amounts determined? Benefit calculations incorporate multiple factors including scheme type, registration duration, contribution history, where applicable, and government guidelines. The code establishes minimum benefit thresholds while providing flexibility for enhancements based on fund availability and periodic reviews. Inspectors cum facilitators serve a dual role in implementing the code, providing both regulatory enforcement and compliance guidance. Appointed by government authorities with specialized expertise, they conduct inspections, offer guidance, review documentation, and facilitate dispute resolution, representing a shift from purely punitive approaches to a more collaborative compliance framework. Inspectors cum facilitators. Appointment. The central government, for Chapters 3 and IV, and the appropriate government, for other provisions, appoint inspectors cum facilitators to implement this code effectively. They operate under a structured inspection scheme that incorporates web-based inspections and randomized selection to ensure fairness and objectivity. The appropriate government provides necessary supporting staff and infrastructure to enable inspectors cum facilitators to perform their duties efficiently. For specialized sectors, the government appoints individuals with relevant technical expertise to address industry-specific compliance requirements. Powers and duties. Inspectors cum facilitators shall provide compliance guidance to employers and employees, conduct systematic inspections of designated establishments, interview and examine persons present on premises, request and review relevant documentation, search, seize, or duplicate essential records, when necessary investigate workplace accidents and hazardous incidents, issue detailed improvement notices with specific remediation steps, recommend prosecution for significant violations, facilitate resolution of employer-worker disputes. The code introduces inspectors cum facilitators as a progressive approach that balances enforcement with advisory responsibilities, promoting compliance through guidance rather than solely through punitive measures. This represents a fundamental shift from traditional inspection regimes toward a collaborative framework that maintains regulatory oversight while supporting business operations. This dual role creates a more productive environment for both businesses and workers, safeguarding worker rights while enhancing ease of doing business through streamlined compliance processes. Frequently asked questions. What is an inspector cum facilitator? A government official with dual responsibility for regulatory enforcement and compliance guidance. They function as both advisors and monitors, helping businesses understand requirements while ensuring adherence to code provisions. Can inspectors cum facilitators enter any workplace? Yes, they possess legal authority to enter, inspect, and examine any workplace under their jurisdiction at reasonable times, with or without prior notification, though they generally follow established protocols. Do they only focus on enforcement? No, their primary function is to facilitate compliance through education and guidance, with enforcement actions reserved for persistent or serious violations that pose significant risks. How are inspection targets determined? The code implements a transparent selection system including randomized web-based selection, risk-based assessments, complaint-driven investigations, and follow-up verification visits. What constitutes proper conduct during an inspection? Full cooperation, prompt provision of requested documentation, and facilitating employee interviews as needed. Maintaining comprehensive records demonstrates good faith compliance efforts. What qualifications do inspectors cum facilitators possess? They typically hold specialized qualifications in labor law, industrial relations, occupational safety, or related fields, complemented by training in regulatory compliance and dispute resolution techniques. What determines inspection frequency? Frequency varies based on risk assessment metrics, compliance history, and industry sector classification. High-risk establishments or those with previous violations face more frequent inspections. What appeal mechanisms exist for challenging decisions? The code establishes a structured appellate process through which parties can challenge decisions, improvement notices, or penalties through designated channels within specified time frames. Offenses and penalties, common questions. The code outlines significant penalties for compliance failures, including imprisonment and fines for non-payment of contributions, illegal wage deductions, dismissal during pregnancy, record-keeping failures, and obstruction of inspectors. Corporate officers may be held personally liable for violations. Understanding the penalties under the code is essential for compliance. Below are the key points about offenses, with common questions addressed in our comprehensive FAQ guide. Failure to pay contributions, imprisonment up to 3 years with minimum 1 year for non-payment of employees' deducted contribution, plus fine of 1 lakh rupees. Employers must ensure timely remittance of all deducted amounts to avoid severe penalties. Courts generally take a strict view of deliberate non-payment of employee contributions. Deduction from wages, fine up to 50,000 rupees for deducting employer's contribution from employees' wages. This violation undermines the principle that employer contributions should be separate from employee compensation. Regular audits can help ensure compliance with contribution requirements. Dismissal during pregnancy, imprisonment up to 6 months or fine up to 50,000 rupees, or both, for dismissing a woman during pregnancy. The protection extends throughout the pregnancy period and maternity leave. Employers must maintain proper documentation of any legitimate terminations unrelated to pregnancy. Repeat offenses, enhanced penalties for second or subsequent offenses, including imprisonment up to 3 years and fine of 3 lakh rupees. The look-back period for determining repeat offenses is typically 5 years from the first conviction. Courts may consider the pattern of violations when determining sentences. Non-maintenance of records, fine up to 50,000 rupees for failure to maintain proper records as required under the code. This includes employment records, contribution payments, and benefit disbursements. Digital record-keeping systems that automate compliance can help prevent such violations. Obstruction of inspectors, imprisonment up to 1 year or fine up to 1 lakh rupees, or both, for obstructing inspector cum facilitators in the discharge of their duties. This includes refusing entry, concealing information, or providing false documents during inspections. Corporate responsibility. When a company commits an offense, every person directly in charge and responsible for the conduct of business shall be deemed guilty, unless they prove the offense was committed without their knowledge. Directors, managers, and officers should establish clear compliance protocols. Chapter 12 provides for offenses and penalties under the Code, with graduated penalties based on the nature and severity of violations. It aims to ensure compliance through deterrence while also providing for compounding of certain offenses. The penalties reflect the importance placed on worker welfare and social security under the new Integrated Labor Code system. For detailed answers to frequently asked questions about these provisions, please refer to our comprehensive FAQ document, which covers implementation, exemptions, and compliance requirements in simple, easy-to-understand language. Regular training sessions for HR and management teams can help ensure organizational awareness of these critical compliance requirements. Compounding of offenses. Compounding allows first-time, less severe offenses to be resolved by paying 50 to 75% of maximum fines without court proceedings. This mechanism is unavailable to repeat offenders and for serious violations, providing efficient resolution while maintaining deterrence. The Code establishes a mechanism for compounding certain offenses, designed to streamline resolution of non-compliance issues without lengthy court proceedings. This approach balances enforcement with facilitation, prioritizing remediation over punishment while maintaining appropriate deterrence. What offenses can be compounded? First-time offenses punishable with fine only or imprisonment up to 1 year plus fine are eligible for compounding. This covers procedural violations like failure to submit returns, record-keeping deficiencies, and registration defaults. Serious violations affecting employee health, safety, or fundamental rights remain non-compoundable. What is the compounding amount? For offenses punishable with fine only, 50% of the maximum fine. For offenses involving imprisonment up to 1 year plus fine, 75% of the maximum fine. Payment must be remitted within 60 days of receiving the compounding notice. All amounts are directed to the Social Security Fund, ultimately benefiting workers. Who cannot compound offenses? Repeat offenders within a 3-year period are ineligible, as are cases where prosecution has already commenced. This restriction prevents habitual violators from exploiting the compounding provision and ensures persistent non-compliance faces stricter enforcement action. What happens after compounding? Upon payment, the offender receives immunity from prosecution for that specific violation. The matter is considered fully resolved, allowing employers to redirect focus toward improving compliance rather than defending against legal proceedings. Importantly, compounding creates no precedent for future violations. Vacancy reporting to career centers. Employers with 20-plus employees must report all job vacancies to career centers within 15 days, file quarterly returns, and maintain records for 3 years. This system promotes labor market transparency while preserving employer hiring autonomy. Key requirements. Employer obligation. Employers with 20-plus employees must report all vacancies to designated career centers within 15 days of a position becoming available, regardless of industry or location. Reporting format. Submit vacancy details electronically through the National Employment Portal using the prescribed form. Include job title, qualifications, experience requirements, salary range, and employment terms. Return filing. File quarterly vacancy returns even if no vacancies occurred during that period. Includes summaries of positions filled, recruitment methods used, and current employment statistics. Record access. Maintain vacancy and recruitment records for at least 3 years. Executive officers and authorized labor officials have legal right to access these records for compliance verification and statistical purposes. Chapter 13 of the Employment Code establishes this comprehensive vacancy reporting system that serves multiple purposes, connecting job seekers with employers, enabling accurate labor market monitoring, and supporting evidence-based policy development. While employers must report all vacancies as prescribed, they maintain complete freedom to recruit candidates through any channel they choose for, whether private agencies, direct hiring, or internal promotions. Frequently asked questions. FAQs. Key vacancy reporting requirements. Employers with 20-plus employees must report job openings within 15 days, file quarterly returns, and maintain records. While reporting is mandatory, hiring decisions remain at the employer's discretion. Non-compliance may result in penalties. What is vacancy reporting? Vacancy reporting is the mandatory process through which employers notify career centers about available job positions, facilitating effective matching between job seekers and employment opportunities. Who is exempt from vacancy reporting? Exemptions include agricultural establishments, domestic service employers, legislative staff positions, temporary jobs lasting fewer than 90 days, and small establishments with fewer than 20 employees. Do I need to hire candidates referred by career centers? No. While reporting vacancies is mandatory, employers maintain complete autonomy to recruit candidates through any channel of their preference, including private agencies or internal promotions. What records must employers maintain? Employers must maintain comprehensive records including working days, hours worked, wages paid, leave entitlements, employee identification numbers, workplace accidents, and all statutory deductions. What is the deadline for reporting vacancies? Employers must report all vacancies to the designated career centers within 15 days of the position becoming available or being created within the organization. How do I report vacancies electronically? Vacancies can be submitted through the official National Employment Portal using your registered employer account or via secure email to your designated regional career center. Are there penalties for not reporting vacancies? Yes. Non-compliance with vacancy reporting requirements may result in significant monetary penalties, as detailed in Chapter 17 of the Employment Code's enforcement provisions. How often must employers file vacancy returns? Employers are required to file quarterly vacancy returns documenting all positions that became available during that period, even if those positions were filled immediately. Can small businesses get assistance with vacancy reporting? Yes. Local career centers offer comprehensive training programs and support services at no cost to help small businesses meet their vacancy reporting obligations efficiently. Do I need to report internal promotions as vacancies? Yes. Internal promotions that create subsequent vacancies at lower organizational levels must be reported to career centers as part of compliance requirements. Record maintenance requirements, frequently asked questions. Employers must maintain comprehensive workplace records for at least 5 years, including detailed documentation of wages, hours, and employee information. Records can be physical or electronic but must be accessible for inspection by authorized officials. Non-compliance may result in penalties. What records must employers maintain? Employers must maintain comprehensive records including workdays, hours, wages, leave entitlements, employee identification numbers, workplace accidents, and statutory deductions. Are wage slips mandatory? Yes, employers must provide detailed wage slips to all employees clearly documenting earnings and deductions for each pay period. What workplace notices are required by law? Employers must prominently display notices regarding working hours, holiday schedules, wage rates, and other critical information as mandated by the code. What is the required record retention period? Most employment records must be preserved for a minimum of 5 years, though certain documents may have specific retention requirements. Is submission of returns mandatory? Yes, employers are required to submit periodic returns to the designated authorities according to the schedules specified in the code. What special records apply to construction employers? Construction industry employers must maintain detailed records of cess payments and comprehensive worker information for all building projects. What record formats are acceptable? Records may be maintained in either physical or electronic formats, provided they remain readily accessible for inspection by authorized officials. Who is authorized to inspect employment records? Labor inspectors, Social Security officers, and other government-authorized officials have legal authority to examine workplace records. When must employers report workplace changes? Employers must notify relevant authorities about significant changes such as ownership transfers, facility relocations, or business expansions within the time frame specified by the code. What consequences exist for record-keeping violations? Non-compliance with record-keeping requirements may result in monetary penalties, formal legal notices, or prosecution for serious or repeated violations. The code's record-keeping requirements establish essential transparency and accountability in employment relationships. Maintaining thorough and accurate records benefits both parties for providing employers with valuable workforce management data, while ensuring employees receive their rightful entitlements. Proper documentation facilitates regulatory compliance, expedites dispute resolution, and creates a clear audit trail of employment practices. Employers are strongly encouraged to implement systematic record-keeping protocols and provide adequate training to administrative personnel responsible for maintaining these critical documents. Assessment and recovery of dues. Frequently asked questions. The Social Security Code establishes a comprehensive framework for the assessment and recovery of employer dues, providing authorities with specific powers while ensuring procedural fairness through appeals processes and legal safeguards for all parties involved. Key questions about assessment and recovery procedures under the Social Security Code, including authorities, processes, and legal safeguards. What is the process for assessment of dues? Authorized officers examine employer records to determine amounts payable under the code provisions, conducting assessments based on available documentation and evidence. Who has the authority to assess dues? Officers appointed by the appropriate government are empowered to assess and determine the amounts payable by employers under various provisions of the code. What powers do officers have during inquiries? Officers possess civil court-like powers, including the authority to summon witnesses, require document production, and examine evidence under oath. Will employers get a chance to explain their position? Yes, employers must be given a reasonable opportunity to be heard before any assessment order is issued, ensuring procedural fairness. How can employers appeal against assessment orders? Employers may file appeals with designated appellate authorities within the time frame specified in the code if they dispute the assessment determination. What methods are used to recover unpaid dues? Recovery methods include property attachment and sale, defaulter detention, and appointment of receivers to manage property until dues are satisfied. Can recovery proceedings continue after an employer dies? Yes, recovery proceedings may continue against legal heirs, limited to the value of property inherited from the deceased employer. Is there a time limit for initiating recovery proceedings? Yes, the code specifies time limitations for initiating recovery actions, typically within a prescribed period after the amount becomes due. Can dues be recovered as arrears of land revenue? Yes, any amount due from employers may be recovered as arrears of land revenue, providing government authorities with established recovery mechanisms under revenue laws. Can wages be attached for recovery of dues? Wages generally receive protection against attachment, with specific exceptions outlined in the code to safeguard workers' essential income. Is interest charged on delayed payments? Yes, the code stipulates interest charges on delayed payments to encourage timely compliance with contribution obligations. What happens when a company is under insolvency proceedings? Social Security dues typically receive priority status during insolvency proceedings, though specific regulations apply based on the proceeding type. Can contractors be held liable for principal employers' dues? In specified circumstances, contractors may be held jointly or severally liable for dues related to contract workers as detailed in the code provisions. Are there penalties for obstructing assessment proceedings? Yes, the code prescribes penalties for individuals who obstruct assessment officers or fail to comply with official directives during proceedings. The code establishes streamlined mechanisms to ensure employer compliance with Social Security obligations through balanced assessment and recovery procedures. These processes are designed to be both efficient and fair, providing appropriate protections for all parties while securing worker benefits. By understanding these procedures, employers can maintain compliance, avoid penalties, and contribute effectively to the Social Security framework. Compared to previous legislation, the code offers greater transparency and predictability in enforcement for all stakeholders. Frequently asked questions, Social Security Code. This slide addresses key liability questions under the Social Security Code, explaining who can be held responsible for violations, how individuals can defend against personal liability, and the processes for prosecution and resolution of offenses. Key questions and answers about Social Security provisions explained in clear, accessible language. What is the Social Security Code? A comprehensive legislation that consolidates multiple labor laws related to Social Security benefits into a unified legal framework. Who bears liability when a company violates Social Security regulations? Both the company as an entity and the individuals responsible for company operations are considered liable for violations. Can company directors or officers be held personally accountable? Yes, directors and officers may be held personally accountable if violations occur with their knowledge, consent, or due to their negligence. How can individuals defend against personal liability? They must demonstrate that the violation occurred without their knowledge, or that they exercised all reasonable diligence to prevent the violation. What entities are classified as a company under the code? The term encompasses any corporate body, firm, association, or group of individuals. In partnerships, partners are considered equivalent to directors. Does the code allow prosecution for violations that occurred before its implementation? No, the code explicitly prohibits retroactive prosecution or punishment for offenses committed prior to its enactment. Are there situations where compliance opportunities are not offered before prosecution? Yes, repeat violations of the same nature within a 3-year period may result in immediate prosecution without prior opportunity for compliance. What is the statute of limitations for initiating prosecution? Prosecution proceedings must commence within 1 year from the date when the alleged offense came to the knowledge of the inspector cum facilitator. Can offenses be resolved without court proceedings? Yes, certain offenses can be settled through a compounding process where the offender pays a stipulated amount to avoid formal prosecution. What is the consequence of impeding an inspector's duties? Obstructing an inspector cum facilitator in the performance of their official duties constitutes an offense punishable under the Code. FAQs, prior opportunity before prosecution. The Code establishes a compliance-first approach where employers typically receive an opportunity to rectify violations before facing prosecution, except for repeat offenders or serious infractions. This system balances enforcement with facilitation through the inspector cum facilitator role. What happens before an employer is prosecuted? Before prosecution, the inspector cum facilitator must provide the employer with a written direction and a specified time period to comply with the relevant provisions. Will an employer be prosecuted if they comply with the direction? No. If the employer complies within the specified period, they will not face prosecution proceedings. Are there exceptions to this compliance opportunity? Yes. Repeat violations of the same nature within a 3-year period will not receive a compliance opportunity. What is the purpose of this provision? This provision promotes a compliance-oriented approach, encouraging employers to rectify violations rather than immediately facing legal consequences. What is the role of the inspector cum facilitator? The inspector cum facilitator performs dual functions, enforcing code compliance and facilitating issue resolution before initiating prosecution. How is the compliance time period determined? The inspector cum facilitator assigns a reasonable time period based on the violation's nature and severity, typically between 15 to 45 days. Can the compliance period be extended? Yes. The inspector cum facilitator may grant extensions when employers demonstrate meaningful progress toward compliance but require additional time. Does this provision apply to all code violations? While this provision covers most violations, certain serious infractions involving safety hazards or willful obstruction may face immediate prosecution without prior opportunity for compliance. How does this approach differ from previous labor regulations? This compliance mechanism reform reflects a shift from purely punitive regulation to encouraging voluntary compliance and remediation. What is significant about the inspector cum facilitator role? This role, which replaces the traditional labor inspector, embodies the dual approach of enforcement and facilitation. What is the goal of this reformed system? It aims to improve employer-regulator relationships, while ensuring that the fundamental protections established by the Code remain upheld throughout the employment ecosystem. Aadhaar serves as the primary identification system for Social Security under the Code, enabling registration, benefit claims, career services, and integration of foreign workers while ensuring secure, efficient delivery of benefits with strong privacy protections. Aadhaar-based identification. Key applications of Aadhaar under the Code. Registration. Mandatory for registration as a member or beneficiary under the Code ensures accurate identification and prevents duplication of records. Serves as the primary 12-digit verification mechanism for establishing identity. Reduces administrative burden through streamlined verification processes. Benefit claims required for claiming cash benefits, medical assistance, or pension ensures benefits reach intended recipients through direct verification. Eliminates ghost beneficiaries from the system. Strengthens transparency and accountability in benefit distribution. Career services necessary for accessing career center services. Facilitates accurate tracking of employment history and job placements. Links individuals to appropriate training and skill development programs. Enables seamless integration with other employment databases. Foreign workers. Mandatory for foreign employees upon meeting residency criteria. Integrates international workers into the National Social Security Framework. Ensures equal access to entitled benefits during Indian employment. Simplifies compliance with labor regulations for foreign nationals. Implementation and benefits. Ensures targeted delivery of Social Security benefits, while minimizing leakages. Accelerates digitization of Social Security administration. Aligns with the government's Digital India initiative. Enables real-time identity Verification with robust authentication reduces processing times while maintaining high security standards, facilitates benefit portability across states for migrant workers, implements a phased integration approach with alternatives for those without Aadhaar, incorporates data privacy safeguards in accordance with Supreme Court guidelines, registration and benefit claim procedures, documentation requirements and compliance timelines, exception handling and privacy protections, technical aspects of Aadhaar authentication, exemption provisions, frequently asked questions. Exemptions allow establishments with superior benefit schemes to operate outside certain code requirements. These 3 exemptions are granted by appropriate governments after consultation, can be extended or revoked based on compliance, and primarily apply to Provident Fund and employee state insurance provisions while maintaining strict management of funds and records. Below are common questions about exemption provisions under the Social Security Code, explained in plain language for better understanding. These exemptions provide flexibility for employers while safeguarding employee welfare. What is an exemption under the code? An exemption allows an establishment to operate outside certain code requirements when they already provide equal or superior benefits through their existing schemes. Who can grant exemptions? The appropriate government, central or state, grants exemptions through official notification in the Official Gazette after completing the required process. What conditions apply for exemption eligibility? Establishments must demonstrate that their benefits equal or exceed code requirements, satisfy all eligibility criteria, and prove that the exemption genuinely advantages employees in terms of coverage and service quality. What is the duration of an exemption? Exemptions initially last for 3 years and may be extended according to established rules. The appropriate government conducts compliance reviews before approving any extensions. Is a consultation process required for exemptions? Yes, the appropriate government must consult with the relevant Social Security organization before granting any exemption to ensure thorough evaluation of alternative arrangements. Can the government revoke exemptions? Yes, exemptions may be revoked if an establishment fails to maintain compliance with stipulated conditions or if their benefit provisions fall below the Code's statutory standards. Which specific chapters qualify for exemption? Exemptions primarily apply to provisions under Chapter 3 Employees Provident Fund and Chapter 4 Employee State Insurance, provided alternative arrangements meet all specified criteria. How are employees' accumulated funds managed in exempted establishments? Accumulated funds must be administered according to strict guidelines ensuring security, appropriate investment practices, and prompt benefit disbursement to eligible employees. Do record-keeping requirements apply to exempted establishments? Yes, exempted establishments must maintain comprehensive records of all contributions, disbursed benefits, and other relevant information as specified in their exemption conditions. Note, the Code strikes a balance between standardized Social Security and flexibility for employers with superior benefit systems. This approach recognizes that some employers have established more favorable schemes while ensuring all workplaces maintain minimum standards. Power to defer or reduce contributions. During national emergencies like pandemics or disasters, the central government can temporarily defer or reduce mandatory Social Security contributions for up to 3 months extendable, providing crucial financial relief to affected employers and employees while preserving the integrity of the Social Security system. The central government possesses authority to provide temporary relief during exceptional circumstances, emergency situations, during pandemics, endemics, or national disasters. The central government may defer or reduce employers' and employees' contributions. This provision acknowledges that extraordinary events can create significant financial strain for businesses and workers alike. Scope. This authority applies specifically to contributions mandated under Chapter 3 Provident Fund and Chapter 4 Employee State Insurance, covering all statutory contributions normally required from both employers and employees. Duration. Relief measures may be implemented for up to 3 months initially. The central government can extend this period through subsequent orders if emergency conditions persist, based on ongoing assessment of economic and social factors. Coverage. Relief measures may apply nationwide or target specific regions as detailed in the government order. This targeted approach enables authorities to focus relief on the most severely affected areas, rather than implementing uniform policies across regions with varying impact levels. Frequently asked questions. When can contributions be deferred? During officially declared pandemics, endemics, or national disasters as determined by appropriate government authorities. Who has the authority to reduce contributions? Only the central government, following thorough situation assessment and stakeholder consultation. What is the maximum period for contribution reduction? Initially 3 months, with possible extensions through subsequent orders if circumstances warrant. Can relief measures target specific geographic areas? Yes, measures may apply nationwide or only to specifically designated regions, depending on the emergency's geographic impact. Which specific contributions qualify for deferment? Those mandated under the Provident Fund or Employee State Insurance chapters of the Social Security Code. Does deferment eliminate the payment obligation? No, deferment postpones payment to a later date, while reduction lowers the required amount. Neither option eliminates the underlying obligation. Is a formal application required for this relief? No. Central government orders for deferment or reduction automatically apply to all qualifying establishments in the specified regions. Will deferred contributions accrue interest? The deferment order will explicitly state whether interest applies, based on the emergency situation's nature and severity. These provisions create a balanced mechanism for the central government to provide timely relief during extraordinary circumstances, while preserving the Social Security system's integrity. By allowing temporary adjustments to contribution requirements during severe economic disruptions, the code helps businesses maintain liquidity and sustain employment while acknowledging economic realities during crisis periods. It's worth emphasizing that these measures are strictly temporary, with clear duration limits to safeguard the Social Security system's financial sustainability. Before implementing such relief, government authorities conduct careful evaluations based on the emergency's severity, considering both immediate worker welfare needs and the long-term viability of Social Security funds. Liability and transfer of establishment. When an establishment changes ownership, both former and new employers share joint liability for Social Security obligations up to the transfer date. This ensures continuous protection of employee benefits during transitions, with the new owner's liability limited to the value of acquired assets. The Social Security Code establishes clear provisions for liability continuity when an establishment changes ownership, safeguarding workers' rights throughout transition periods. Transfer types include sale, gift, lease, license, or any other transfer mechanism that shifts ownership or management control of an establishment. Joint liability. Former and new employers are jointly and severally liable for all statutory obligations, ensuring uninterrupted protection of employee benefits. Liability period encompasses all amounts due under the code up to the transfer date, including outstanding contributions and accrued benefits. Transfer relimitation. Liability is capped at the value of assets acquired through the transfer, providing necessary certainty for acquiring entities' due diligence. Potential acquirers should conduct comprehensive audits of all outstanding Social Security obligations prior to finalizing any transfer agreements. Must explicitly address the allocation of pre-existing liabilities between all parties involved. Employee communication. Workers require clear notification about the transfer and confirmation of their benefit. Continuity records transfer. All Social Security and employment documentation must be properly transferred to the succeeding entity. Regulatory notification. Relevant authorities must receive timely notification about ownership changes within mandated time frames. This provision effectively prevents employers from circumventing Social Security obligations through strategic ownership transfers. It simultaneously reassures employees that their accumulated benefits remain secure regardless of establishment ownership or management changes. Note: a comprehensive FAQ resource addressing specific scenarios and clarifying obligations could serve as valuable supplementary material. Such documentation would cover compliance requirements, necessary documentation, and procedures for transferring Social Security registrations between entities. Protection against attachment, FAQs. Social Security benefits receive robust legal protection against attachment by courts or creditors. Funds in provident, pension, and insurance accounts cannot be seized for any debts with priority status during employer bankruptcy. This protection extends automatically to death benefits and dependents' entitlements. We've compiled questions about the protection of Social Security benefits. This comprehensive guide helps employees understand their rights and the robust safeguards protecting their Social Security funds. Here are the most common questions. What Social Security funds are protected from attachment? All amounts in provident funds, pension funds, and insurance funds under the code are fully protected from attachment by any court. Can creditors claim my Social Security benefits? No, your benefits are completely shielded against any debt or liability and cannot be seized even under court orders for debt recovery. Are death benefits paid to my family protected? Yes, all amounts payable upon death to your nominees or family members remain entirely free from any debts or liabilities you may have incurred. What happens to my benefits if my employer goes bankrupt? Your benefits receive priority claim status and must be paid before other debts during any insolvency proceedings. What if I have an existing loan against my provident fund? Existing loans taken against your provident fund before the code implementation remain valid, while new attachment restrictions will apply to the remaining balance. Can a court order attachment under any circumstances? The only exception is when the fund or board itself seeks to recover amounts that were incorrectly paid or obtained through fraudulent means. Do I need to take any action to ensure my benefits are protected? No. These protections apply automatically under the code without requiring any application or special request from employees. Are my dependents' benefits also protected? Yes, all benefits payable to dependents, including children's education allowances and survivor pensions, enjoy identical protection against attachment. Application procedures, eligibility criteria, benefit calculations, special circumstances for all explained in plain language to help employees fully understand their rights. These resources are available in multiple languages, accessible formats, ensuring all workers can comprehend these vital protections regardless of their educational background. Employer responsibilities include prominently displaying information about these protections in workplaces, including protection information and employee handbook support resources. The Social Security Department has established a dedicated helpline where employees can receive personalized answers about attachment protection for their specific situations. Presentation guidelines emphasize the absolute nature of these protections, for they represent one of the strongest safeguards in the entire code. Start by highlighting the fundamental principle that Social Security benefits are completely immune from attachment. When going through the FAQs, pause after each question to let the information sink in. The first 4 questions establish the core protections, while the next 4 address special circumstances if time permits. Mention that the complete FAQ resource addresses more complex scenarios like international transfers, self-employed individuals, and gig economy workers. Highlight that these protections apply universally regardless of employment type or industry. Conclude by emphasizing practical implementation for employers' obligation to display this information. Availability of the helpline for personalized assistance. The code's commitment not just to establishing protections in law but ensuring they're accessible in practice. Be prepared for questions about specific judicial proceedings, how these protections interact with other legal frameworks like bankruptcy proceedings. If such questions arise, clarify that these Social Security protections generally supersede other claims except in cases of fraud. The Social Security Code ensures seamless transition through continuity of existing organizations, schemes, exemptions, and legal actions, with automatic fund transfers and comprehensive protection of prior administrative decisions. A detailed FAQ resource supports stakeholders through this regulatory transformation. Transitional provisions and FAQs. Key transition provisions. Existing organizations. All organizations established under previous laws will seamlessly continue under the new code, preserving their operational authority and legal status. This continuity applies to executive committees, governing boards, and all administrative bodies. Existing schemes. Current benefit schemes remain fully operational for 1 year or until specifically replaced by new equivalents. This strategic approach ensures all beneficiaries receive uninterrupted benefits throughout the transition period. Existing exemptions. All exemptions granted under previous legislation remain valid until their scheduled expiration or formal revocation. Organizations benefit from automatic carryover of these exemptions without the administrative burden of reapplication. Prior actions. All administrative actions taken under previous laws are automatically validated under the new code. This comprehensive protection covers registrations, claim adjudications, benefit disbursements, and enforcement proceedings initiated before the code's implementation. Legal proceedings. Any investigations, legal actions, or appeals that commenced under repealed laws will continue to their natural conclusion under those original legal frameworks, regardless of the code's implementation date. Fund transfers. All financial resources accumulated under previous legislation will transfer automatically to their corresponding funds under the new code, maintaining identical purpose and benefit structures without disruption. The code establishes a methodical transition from fragmented legislation to an integrated framework, ensuring continuous delivery of Social Security benefits. This carefully designed approach provides stakeholders with adequate adaptation time while safeguarding existing rights and benefits. To support this transition, we've developed a comprehensive resource of questions (FAQs) with straightforward answers, making these complex changes accessible to all stakeholders. These practical FAQs address critical concerns including implementation timelines, specific documentation requirements, adjusted contribution calculations, new digital compliance platforms, and jurisdictional authority under the Unified Code. This resource specifically targets the most common questions from employers, employees, and Social Security administrators, providing clear guidance through each phase of this significant regulatory transformation. Presentation notes: when presenting this slide, emphasize that these transitional provisions were specifically designed to address stakeholder concerns about disruption. Highlight that organizations should review their current exemptions to understand their continued validity timeframes. If asked about specific timelines, note that the one-year continuation period for schemes begins from the date of code notification, not implementation. For questions about legal proceedings, explain that cases will continue under original laws to prevent procedural complications. FAQ resource details: be prepared to discuss the FAQ resource in more detail. Mention that it's available in multiple languages and accessible formats. The most frequently consulted sections relate to contribution calculations and digital compliance requirements. The FAQ document addresses questions at different stakeholder levels, from basic queries for individual workers to complex compliance scenarios for large enterprises and multi-state employers. The Social Security Code ensures seamless transition through continuity of existing organizations, schemes, exemptions, and legal actions, with automatic fund transfers and comprehensive protection of prior administrative decisions. A detailed FAQ resource supports stakeholders through this regulatory transformation. Transitional provisions and FAQs. Key transition provisions: existing organizations. All organizations established under previous laws will seamlessly continue under the new code, preserving their operational authority and legal status. This continuity applies to executive committees, governing boards, and all administrative bodies. Existing schemes. Current benefit schemes remain fully operational for 1 year or until specifically replaced by new equivalents. This strategic approach ensures all beneficiaries receive uninterrupted benefits throughout the transition period. Existing exemptions. All exemptions granted under previous legislation remain valid until their scheduled expiration or formal revocation. Organizations benefit from automatic carryover of these exemptions without the administrative burden of reapplication. Prior actions. All administrative actions taken under previous laws are automatically validated under the new code. This comprehensive protection covers registrations, claim adjudications, benefit disbursements, and enforcement proceedings initiated before the code's implementation. Legal proceedings. Any investigations, legal actions, or appeals that commenced under repealed laws will continue to their natural conclusion under those original legal frameworks, regardless of the code's implementation date. Fund transfers. All financial resources accumulated under previous legislation will transfer automatically to their corresponding funds under the new code, maintaining identical purpose and benefit structures without disruption. The code establishes a methodical transition from fragmented legislation to an integrated framework, ensuring continuous delivery of Social Security benefits. This carefully designed approach provides stakeholders with adequate adaptation time while safeguarding existing rights and benefits. To support this transition, we've developed a comprehensive resource of questions (FAQs) with straightforward answers, making these complex changes accessible to all stakeholders. These practical FAQs address critical concerns including implementation timelines, specific documentation requirements, adjusted contribution calculations, new digital compliance platforms, and jurisdictional authority under the Unified Code. This resource specifically targets the most common questions from employers, employees, and Social Security administrators, providing clear guidance through each phase of this significant regulatory transformation. Frequently asked questions (FAQs). The Social Security Code consolidates 9 previous labor laws into one framework, extending coverage to all worker categories including gig and unorganized sectors. It provides comprehensive benefits through a unified registration system, while preserving existing entitlements and establishing stronger compliance mechanisms. Below are common questions about the Social Security Code answered in clear, accessible language to help workers, employers, and benefit administrators understand their rights and responsibilities under the new integrated framework. What is the Social Security Code? The Social Security Code is comprehensive of legislation that consolidates 9 previous laws related to workers' benefits and protection into a single, streamlined framework, making it more accessible and easier to implement. Who is covered under this code? The code extends coverage to virtually all workers, including regular employees, construction workers, gig workers, and those in the unorganized sector, regardless of their employment status, wage level, or industry sector. What benefits does it provide? The code provides a comprehensive suite of benefits including retirement pension, health insurance, maternity benefits, compensation for work-related injuries, and provident fund savings, for all designed to ensure financial security throughout a worker's life cycle. How are gig workers protected? For the first time in labor legislation, the code specifically mandates that aggregators, such as ride-sharing or food delivery platforms, contribute a percentage of their revenue to a dedicated Social Security fund for gig and platform workers. When will I receive compensation for work injuries? Compensation is payable for injuries sustained during employment and for occupational diseases listed in the 3rd schedule of the code. Payment is typically disbursed within 30 days after assessment of the disability or condition. Do I need to register separately for each benefit? No. The code introduces a unified registration system where workers register once and can access multiple benefits through a centralized portal, using their unique identification number, significantly reducing bureaucratic procedures. What happens to my existing benefits under the old laws? All existing benefits are fully preserved and will continue without interruption. Your accumulated savings, pension contributions, and insurance coverage remain secure and will transition seamlessly under the new code. Are there penalties for employers who don't comply? Yes. The code establishes stringent penalties for non-compliance, including substantial fines and potential imprisonment for serious violations, particularly those that compromise worker safety or withhold rightful benefits. How do I file a complaint if my benefits are denied? The code establishes multi-tiered grievance redressal mechanisms. Workers can file complaints through a dedicated online portal, at local labor offices, or through authorized representatives like trade unions. Will self-employed workers get benefits too? Yes. The code makes significant provisions for self-employed workers to voluntarily participate in Social Security schemes by making income-based contributions, extending protection to this previously excluded but substantial workforce segment. The Social Security Code represents a paradigm shift in labor welfare, simplifying benefit administration while dramatically expanding coverage to previously excluded workers. Comprehensive implementation rules will be published by the government detailing operational aspects of each benefit scheme. The code's fundamental objectives are to achieve universal coverage, streamline administrative processes, and enhance benefit delivery through digital platforms. Extensive educational campaigns will be conducted to ensure workers fully understand and can effectively access their enhanced rights under this transformative framework. The Social Security Code establishes a 3-tier rule-making structure with the central government having the broadest authority, followed by state governments and the ESI Corporation, each with defined jurisdictions. All rules require legislative oversight and typically involve stakeholder consultation. Rule-making powers. Hierarchical structure of rule-making authority. Central government, comprehensive authority to establish rules across all code chapters, covering definitions, procedures, forms, and administrative provisions. 1. State governments, authority to develop rules within state jurisdiction including establishment registration, inspection protocols, and local administration. 2. Corporation, authority to create regulations for ESI administration, fund management, benefit distribution, and operational guidelines. 3. The code delegates substantial rule-making powers to these 3 entities to facilitate detailed implementation of its provisions. This delegation enables administrative flexibility and adaptation to evolving circumstances without requiring legislative amendments to the code itself. All rules and regulations must be presented before Parliament or state legislatures as applicable, ensuring proper oversight of delegated legislation. This process maintains democratic accountability throughout the implementation process. Frequently asked questions. Who makes rules under the Social Security Code? The central government, state governments, and the ESI Corporation each have designated rule-making authority for specific aspects of the code. The central government maintains the most extensive authority spanning all code chapters. Do these rules require formal approval? Yes, all rules must be presented presented before Parliament or state legislatures for proper oversight. This process enables elected representatives to review and potentially challenge any rule that exceeds the authority granted by the primary legislation. Can the public contribute to rule development? Yes, draft rules are typically published for public comment before finalization. This consultative approach allows stakeholders, including employers, employees, trade unions, and subject matter experts, to provide input that may significantly influence the final regulations. What happens if rules conflict with the code? The code's provisions always take precedence over any conflicting rules or regulations. Courts have the authority to invalidate subordinate legislation that contradicts the parent act, as rule-making authority cannot exceed the powers granted by the legislature. How can I access the latest rules? Rules are published in the official gazette and on relevant ministry websites. Additionally, legal databases and professional services offer regularly updated compilations of Social Security regulations with helpful annotations and explanatory notes. Rulemaking process. The rulemaking process follows a standardized procedure: initial drafting by ministry officials, stakeholder consultation, legal review, final notification following approval by the appropriate authority. This systematic approach ensures that rules are technically sound, practically implementable, and legally valid. The Employees Insurance Court is a specialized judicial body established by state governments to exclusively adjudicate ESI-related disputes. Presided over by qualified judicial officers, these courts possess civil court powers, follow simplified procedures, and resolve cases faster than regular courts. Appeals against their orders may be filed with the High Court within 60 days if they involve substantial questions of law. Employees Insurance Court. Structure and functions. Constitution. State government constitutes employees' insurance courts for specified local areas through official gazette notification. Multiple courts may be established based on regional requirements and caseload to ensure accessibility for all stakeholders. Qualification. Judges must be judicial officers or legal practitioners with at least 5 years of standing. Appointments are based on experience in labor matters, knowledge of Social Security laws, and demonstrated judicial temperament suitable for resolving insurance disputes. Jurisdiction. Exclusive jurisdiction over all EC-related disputes including employee status, contribution rates, and benefit claims. Courts adjudicate matters concerning contribution recovery, dependent determination, and disputes regarding the applicability of the scheme to specific establishments. Powers. Courts possess civil court powers for summoning witnesses, compelling document production, and administering oaths. They can enforce attendance, examine witnesses under oath, receive evidence through affidavits, issue commissions, and review their own orders when necessary. Appeals process. Appeals against employees' insurance court orders may be filed with the High Court if they involve substantial questions of law. Such appeals must be filed within 60 days from the date of the challenged order. The Code establishes specialized employees' insurance courts to ensure expert and expeditious resolution of disputes relating to the employee state insurance scheme. These courts maintain the integrity of the Social Security system by providing a dedicated forum for addressing grievances, typically resolving matters significantly faster than regular civil courts. Frequently asked questions. How do I file a case with the Employees Insurance Court? Submit your application to the court clerk in your local area with all supporting documents. Clearly state the relief sought and grounds for your claim. What is the time limit for filing a case? Cases must be filed within 3 years from when the cause of action arose. The court may accept delayed filings if sufficient cause is demonstrated. Can I represent myself or do I need a lawyer? Self-representation is permitted, but legal counsel is recommended for complex cases. Some courts allow representation by authorized trade union representatives. What documents should I bring when filing a case? Bring your ESI card, employment details, relevant medical records, correspondence with the ESI Corporation, and any rejection orders you have received. Are there any court fees required? Employees' insurance courts typically charge minimal or no fees, unlike regular civil courts, ensuring accessibility for workers. How long does it take to resolve a case? Most cases are resolved within 6-12 months, depending on complexity and caseload, significantly faster than regular civil courts. These specialized courts operate with simplified procedures to make justice accessible to workers without resources for prolonged litigation. Presiding officers are trained to understand the socio-economic context of insurance disputes enabling them to deliver judgments that are both legally sound and contextually appropriate. The competent authority for gratuity serves as a specialized adjudicating body with civil court powers, appointed by the government to determine gratuity amounts, resolve disputes, and ensure timely payments to eligible employees who have completed at least 5 years of service. Competent authority for gratuity, appointment and powers. Appointment: the appropriate government designates competent authorities to implement gratuity provisions under the Code. Qualifications: appointed officials must possess prescribed qualifications and relevant experience to effectively discharge their responsibilities. Jurisdiction: each competent authority oversees establishments within their specifically designated geographical area. Civil court powers: these authorities can summon witnesses, examine them under oath, require document production, and issue legally binding decisions. Core functions: they determine gratuity amounts, resolve disputes between parties, and ensure timely and proper payments to eligible employees. Procedural framework: application filing: employee or legal heir submits gratuity claim application to employer. If rejected or disputed, application is filed with the competent authority within specified time frame. 1. Examination and hearing: competent authority examines claim documentation, issues notices to concerned parties, and conducts hearings where all parties may present evidence and arguments. 2. Adjudication: authority determines the gratuity amount based on service records, applicable formula, and legal provisions after considering all submitted evidence. 3. Order issuance: written order issued specifying the gratuity amount, payment timeline, interest if applicable, and reasoning behind the decision. 4. Payment enforcement: competent authority ensures compliance with the order, with authority to initiate recovery proceedings against defaulting employers. 5. Legal framework: appeals process: aggrieved parties may appeal decisions to the appropriate appellate authority within 60 days of receiving the order. Final authority: the appellate authority's decision is considered final and binding unless challenged in a high court on specific questions of law. Employer obligations: employers must notify the competent authority within 15 days of receiving any gratuity claim from employees. Compliance penalties: failure to pay gratuity within 30 days of it becoming due may result in interest charges and additional penalties under the Code. Frequently asked questions: what is gratuity? A monetary benefit paid by employers to workers as recognition for their service upon leaving employment. Who is eligible for gratuity? Employees who have completed at least 5 consecutive years of service with the same employer. How is gratuity calculated? Last drawn salary x 1526 x number of completed years of service. Is gratuity tax exempt? Yes, up to 20 lakh under Section 10(10) of the Income Tax Act. When can gratuity be forfeited? Only when services are terminated due to proven misconduct causing financial loss to the employer. What recourse exists if an employer refuses payment? Employees may file a complaint with a competent authority, who can order payment with applicable interest. Can creditors attach gratuity payments? No, gratuity is protected and cannot be attached in execution of any court decree. Recovery officers are government-appointed officials with quasi-judicial powers who enforce Social Security payment compliance. They operate through legally binding recovery certificates and employ multiple recovery methods including property attachment, garnishee orders, and detention of defaulters, while following due process and prioritizing business assets before personal property. Recovery officer appointment: the central or state government appoints qualified officers to serve as recovery officers. Appointees must possess relevant qualifications and experience in legal or administrative matters to effectively execute recovery proceedings. These officers function with quasi-judicial powers under governmental authority to fulfill their mandated responsibilities. Recovery certificate: the recovery process commences when an authorized officer or competent authority issues a certificate specifying the amount in arrears. This certificate constitutes a legally binding document detailing the principal amount due, accrued interest, and other pertinent information. It serves as conclusive evidence for initiating recovery proceedings and carries the same legal weight as a civil court decree. Methods of recovery: recovery officers may secure payment through attachment and sale of property, arrest and detention of defaulters, or appointment of receivers to manage assets. They are empowered to issue garnishee orders, intercept tax refunds, and recover dues from third parties indebted to the defaulter. The recovery procedures follow protocols similar to those in the Income Tax Act, with necessary adaptations as specified in the regulations. All recovery actions must adhere to due process, including serving proper notice and providing opportunity for hearing before implementing coercive measures. Priority of recovery. Recovery officers must first attempt to recover dues from the establishment's assets before proceeding against the employer's personal property. This sequential approach ensures business assets are fully utilized before targeting personal assets of the employer. Comprehensive documentation of all proceedings and recovered amounts must be maintained by recovery officers. Recovered funds are distributed according to a prescribed priority order among various dues under the code. Any surplus amount remaining after satisfying all dues must be promptly refunded to the employer. The code establishes a comprehensive recovery mechanism through recovery officers with extensive powers to collect amounts due, ensuring effective enforcement of Social Security obligations. These officers must adhere to principles of natural justice and follow prescribed procedures meticulously while exercising their authority. Aggrieved parties may file appeals against recovery officers' actions with designated appellate authorities within stipulated time frames. The appellate authority may stay recovery proceedings on valid grounds, typically after securing partial payment of the disputed amount. The Medical Benefit Committee, constituted by the central government under Section 10 of the ESI Act, provides expert guidance on healthcare delivery for insured workers. Comprised of medical professionals and stakeholders, it establishes quality standards, evaluates services, and recommends improvements to ensure optimal healthcare benefits for millions nationwide. Medical Benefit Committee Constitution. The central government constitutes the Medical Benefit Committee to advise the corporation and standing committee on matters related to medical benefits. Committee composition includes medical professionals, government representatives, and insurance sector stakeholders as specified in the constituting notification. Members serve a renewable 2-year term based on performance and willingness to continue. Established under Section 10 of the ESI Act, the committee remains directly accountable to the central government for all recommendations and decisions. Functions: advising on administration of medical benefits and service delivery, establishing standards for quality medical care and treatment, evaluating and monitoring the quality of medical services provided, recommending strategic improvements in healthcare delivery systems, executing additional duties as prescribed by the central government, reviewing and approving medical benefit expenditures for fiscal responsibility, analyzing beneficiary feedback to enhance patient experience, proposing healthcare innovations to improve outcomes for insured persons, coordinating with state health authorities to optimize service integration meetings and proceedings, conducts quarterly meetings with provision for additional sessions when necessary to address urgent matters, convenes special meetings during emergencies or when considering significant policy changes, documents and distributes meeting minutes to the corporation and standing committee for actionable follow-up, ensures recommendations receive appropriate consideration in the policy-making process. Relationship with other bodies. The Medical Benefit Committee collaborates closely with ESI Corporation, providing expert medical insights to inform benefit decisions and implementation strategies. Standing Committee, offering specialized healthcare expertise for operational decisions affecting service delivery. State Medical Commissioners, ensuring standardized quality of medical care across all participating states. The Medical Benefit Committee serves as the cornerstone for quality healthcare delivery within the employee state insurance scheme. Its expert guidance and vigilant oversight help maintain exceptional healthcare standards for millions of workers nationwide, directly contributing to improved health outcomes and worker welfare across India. Note: for comprehensive information about the Medical Benefit Committee, including detailed FAQs, please refer to the supplementary materials. Medical education institutions, frequently asked questions. The ESI Corporation establishes and operates various medical education institutions, including medical, dental, and nursing colleges to enhance healthcare quality for insured persons. These institutions train professionals with specialized knowledge of occupational health and the ESI system, ensuring a dedicated healthcare workforce through service bonds while following national education standards. Below are straightforward answers to common questions about ESI Corporation's medical education initiatives. These FAQs outline key information about how medical education institutions are established and operated under the ESI scheme. What types of institutions can the ESI Corporation establish? The corporation establishes medical, dental, and nursing colleges, along with specialized facilities including paramedical training centers, research institutes, and advanced healthcare education facilities to address various healthcare needs. Why does the ESI Corporation set up these institutions? These institutions enhance healthcare quality for insured persons by training professionals who understand occupational health challenges and the ESI system. This approach improves service delivery, builds a dedicated healthcare workforce, and reduces dependency on external medical resources. Do students need to work for ESI after completing their education? Yes, students must sign a service bond committing to work for the corporation for a specified period, typically 2 to 5 years depending on their specialization. This arrangement ensures the corporation benefits from its educational investment while maintaining a consistent supply of qualified medical professionals. Who can run these medical education institutions? These institutions may be managed by the corporation itself, central or state governments, public sector companies, or other approved organizations. The corporation may also form public-private partnerships, always maintaining appropriate oversight and quality standards through governing bodies. Are these institutions only for ESI beneficiaries? No. While the institutions ultimately strengthen the ESI healthcare network, they admit students through standard medical entrance procedures and follow national education standards. The professionals trained will serve ESI beneficiaries after completing their education. How is admission granted to these institutions? Admissions primarily follow national and state-level medical entrance examinations. Though some seats may be reserved for children of insured persons or ESI employees, all admitted students must meet the eligibility criteria established by regulatory bodies like the National Medical Commission. What facilities are available in these institutions? These institutions feature modern teaching equipment, comprehensive libraries, advanced laboratories, simulation centers, and clinical training facilities. Many are connected to ESI hospitals for practical clinical experience, with infrastructure meeting or exceeding regulatory standards. How are these institutions funded? Funding primarily comes from the ESI Corporation's dedicated educational fund. Additional resources include tuition fees, government grants, and collaborative projects with healthcare organizations. This funding model ensures high-quality education while maintaining financial sustainability. By establishing these medical education institutions, the ESI Corporation demonstrates its commitment to quality healthcare for insured workers. This robust educational ecosystem addresses healthcare workforce shortages and specialized occupational health needs simultaneously. These institutions represent a strategic investment in improving healthcare delivery for workers and their families for generations to come. Occupational disease FAQs. Occupational diseases are specific work-related illnesses listed in the third schedule that qualify for employment injury benefits. These conditions are categorized based on required exposure periods, with eligibility determined through medical certification and employment documentation. The Social Security Code provides a structured framework for compensating illnesses developed through workplace exposure. What is an occupational disease? An occupational disease is any illness specifically listed in the third schedule that directly results from your work activities or workplace environment. When diagnosed with such a disease, it qualifies as an employment injury for benefit purposes. How are occupational diseases categorized? The third schedule organizes diseases into 3 parts. Part A, recognizable regardless of employment duration. Part B, requires minimum 6 months of employment. And Part C, requires specific exposure periods determined by the corporation. When can I claim benefits for an occupational disease? You become eligible for benefits upon diagnosis with a third schedule listed disease related to your specific occupation. Your waiting period varies according to the disease category, A, B, or C, as specified in the regulations. What evidence do I need to support my claim? A complete claim requires an official medical certificate from an authorized physician confirming your diagnosis, employment records documenting your work in the relevant occupation, and comprehensive medical documentation of your symptoms, treatment, and prognosis. Can pre-existing conditions qualify as occupational diseases? Pre-existing health conditions may qualify if medical evidence demonstrates that your work substantially aggravated or accelerated the condition beyond its natural progression. Each case undergoes individual assessment based on detailed medical evidence and occupational history. Who determines if my illness is work-related? Corporation-appointed medical officers make this determination after conducting a thorough examination, reviewing your complete medical history, and assessing the connection between your specific work duties and the diagnosed condition. The code acknowledges that occupational illness is typically developed gradually through prolonged exposure rather than from single incidents, and establishes a structured framework for fair compensation. Familiarizing yourself with these provisions ensures you can access your entitled benefits when facing health challenges resulting from workplace exposures or activities. Employment Injury Presumption (FAQs). The code establishes favorable presumptions for workers, automatically considering accidents during work hours, on company premises, while commuting, using employer transport, during breaks, and at work events as employment injuries eligible for compensation. Key questions about employment injury presumptions under the code that protect workers' rights and streamline the compensation process. What is the basic presumption for employment injuries? Any accident occurring during work hours is presumed to arise from employment unless proven otherwise. This creates a favorable position for workers seeking compensation. Are accidents on company premises covered? Yes, accidents on or near workplace premises are considered employment injuries, including those during emergency rescue work or while using workplace facilities. Does coverage include my commute to work? Commuting accidents between home and workplace are covered when there's a clear connection between circumstances, time, and place. This protection extends beyond the physical workplace. What about transport provided by my employer? Accidents while traveling in employer-provided or arranged transport automatically qualify as employment injuries, whether you're traveling to work, between work locations, or returning home. Are work-related injuries during breaks covered? Yes, injuries sustained during authorized breaks on employer premises are covered as employment injuries, including lunch breaks and rest periods. What if my injury occurred during a work-related social event? Injuries at employer-sponsored events, team-building activities, or company functions may qualify as employment injuries if attendance was expected or encouraged by management. Do I need witnesses to prove my employment injury? While witnesses strengthen your claim, the presumption principle shifts the burden of proof away from you. The code acknowledges the difficulties in documenting workplace accidents. These presumptions simplify the compensation claim process, recognizing that workers often struggle to prove exact accident circumstances. This worker-friendly approach ensures genuine workplace injuries receive prompt attention and appropriate benefits without unnecessary administrative barriers. For specific cases, consult the detailed guidelines or visit facilitation centers for assistance. Facilitation centers for unorganized workers. Dedicated facilitation centers provide vital support to unorganized, gig, and platform workers through information, application assistance, registration services, and scheme enrollment guidance for all designed to ensure vulnerable workers can access their entitled Social Security benefits. Purpose and overview. The code establishes toll-free call centers, helplines, and facilitation centers specifically designed to help unorganized workers, gig workers, and platform workers access vital Social Security benefits. Accessibility. Centers operate in multiple languages and are strategically located in areas with high concentrations of unorganized workers, serving as critical support hubs for vulnerable workforce populations. Information dissemination. Provide clear, accessible information on all available Social Security schemes. Offer detailed explanations of eligibility criteria, benefit packages, and required documentation in simple terms. Conduct regular awareness campaigns in local languages to reach even the most marginalized workers. Application processing. Provide hands-on assistance with filing, processing, and tracking application forms. Offer expert guidance through complex paperwork. Verify document completeness. Provide digital submission support for those with limited technological access or literacy challenges. Registration assistance. Offer personalized support services to help workers navigate the registration process under the code with confidence. Include thorough document verification, identity authentication, and troubleshooting of registration issues. Assist with information updates in the central database. Provide official registration certificate. Scheme enrollment. Provide expert guidance to select and enroll in appropriate Social Security schemes including pension plans, disability coverage, and health insurance. Once registered, tailor recommendations to each worker's specific needs, occupational risks, and financial circumstances. Offer ongoing support for benefit access and claim processing. Additional services. build strong networks with local authorities, employers, and worker associations to maximize impact, maintain comprehensive digital records of registered workers, conduct systematic follow-ups to ensure benefit delivery, gather user feedback to continuously improve services, organize regular workshops and training sessions to educate workers about their rights, available benefits, and the importance of formal registration, empower vulnerable workers to access the protections they deserve, misuse of benefits. The code establishes a comprehensive framework to prevent Social Security benefit misuse through detection systems, fair investigation processes, graduated penalties, and preventive measures, while maintaining appeal rights for affected individuals. The code contains robust provisions to prevent Social Security benefit misuse, empowering government authorities to take decisive action against system abusers while maintaining due process through mandatory hearings before imposing penalties. These safeguards protect scheme integrity while ensuring legitimate beneficiaries remain protected. What constitutes benefit misuse? Any deliberate attempt to obtain benefits through false information, concealed facts, or improper usage. Examples include misrepresenting employment details or income, falsifying disability status, permitting unauthorized benefit card usage, and failing to report eligibility affecting changes in circumstances. How is misuse identified? Through systematic audits, complaint investigations, data analysis, and beneficiary verification. Authorities employ advanced data matching across government databases, conduct random field verifications, maintain whistleblower channels, and increasingly utilize AI to detect suspicious patterns indicative of potential fraud. What happens upon suspicion? The appropriate government conducts a thorough investigation and provides a fair hearing opportunity before taking action. This process includes formal notification detailing allegations, sufficient response time, personal hearings when requested, and comprehensive evidence assessment, all adhering to natural justice principles. What penalties may apply? Consequences range from temporary benefit suspension and repayment requirements to legal action. Severe cases may result in permanent disqualification, proportionate financial penalties, criminal prosecution under the Indian Penal Code, and inclusion in a centralized database to prevent future cross-scheme abuse. Are appeals possible? Yes, affected individuals can appeal through established code procedures with supporting evidence. The multi-tiered appeal process includes progressively senior authority reviews, specific filing time frames, provisions for interim relief in genuine hardship cases, judicial review options, and potential legal aid for those unable to afford representation. What preventive measures exist? The code emphasizes prevention through targeted awareness campaigns, clear rule communication, regular verification processes, and technological solutions including biometric authentication. Educational programs help beneficiaries understand their rights and responsibilities, while staff training focuses on fraud detection without creating barriers for legitimate claimants. Note, the government follows a structured four-step process for addressing benefit misuse: 1. Investigation-based misuse determination; 2. Fair hearing with adequate defense preparation time; 3. Appropriate penalty imposition considering severity and mitigating factors; and 4. Detailed decision notification including appeal rights information. This approach ensures consistent, transparent enforcement while protecting individual rights. Power to remove difficulties. Section 142 grants the central government temporary authority to overcome implementation challenges through special orders, subject to constitutional limitations, a 2-year expiration period, and parliamentary oversight, ensuring both administrative flexibility and democratic accountability. The Code on Social Security, 2020 anticipates potential implementation challenges inherent in new legislation. Section 142 strategically empowers the central government with specific authority to address unforeseen obstacles during the initial implementation phase. Central government authority. When implementation challenges arise, the central government may issue orders establishing necessary provisions to overcome these difficulties. This provides administrative flexibility without requiring formal legislative amendments, ensuring the code can be effectively operationalized despite unexpected hurdles. Constitutional safeguards. Any provisions made under this power must remain consistent with the code's original framework. This critical limitation prevents the executive branch from undermining legislative intent or diluting substantive rights guaranteed under the code. Temporal constraints. This special authority expires 2 years after the code's commencement. This deliberate time restriction prevents indefinite executive adjustments while providing sufficient opportunity to address early implementation issues before the framework fully stabilizes. Democratic accountability. All orders issued under this section must be promptly presented before both houses of Parliament. This transparency mechanism ensures legislative oversight of executive actions and maintains constitutional checks and balances. This provision strikes a careful balance between necessary administrative flexibility and appropriate democratic controls during the transitional implementation period. While enabling practical solutions to emergent challenges, it establishes clear boundaries to prevent overreach. Historical precedent from previous Social Security legislation demonstrates how this power has successfully addressed procedural gaps, resolved ambiguities, and facilitated smooth transitions. Importantly, this authority cannot be invoked to fundamentally alter the rights and obligations established by the Code. For comprehensive guidance on implementation processes, stakeholders should consult the regularly updated supplementary document containing questions FAQs. This resource addresses common implementation queries in accessible language and incorporates references to any orders issued under Section 142. Conclusion and implementation. The Code on Social Security, 2020 unifies 9 laws into a single framework, extends coverage to unorganized and gig workers, simplifies compliance, enables phased implementation, leverages technology, and establishes sustainable funding mechanisms. Successful execution requires coordinated stakeholder efforts and ongoing evaluation. Comprehensive framework. The Code on Social Security, 2020 establishes an integrated social security system encompassing both organized and unorganized sectors. This unification brings diverse schemes under one legislative umbrella, ensuring policy coherence and effective implementation. Universal coverage. The Code extends vital protections to previously neglected categories including unorganized workers, gig workers, and platform workers. This groundbreaking inclusion recognizes the evolving nature of employment in the digital economy and safeguards millions previously working without essential safety nets. Administrative streamlining. By consolidating 9 separate laws into a single code, the legislation dramatically simplifies compliance requirements, eliminates duplicative processes, and creates a more accessible and transparent administrative framework. Progressive implementation. The Code enables phased implementation through strategic notifications, rules, and schemes, ensuring a seamless transition. This measured approach allows stakeholders to adapt their systems while maintaining uninterrupted benefits for recipients. Technological integration. Advanced digital solutions power the registration, contribution, and disbursement processes. Aadhaar-linked systems and comprehensive online portals enhance accessibility, minimize leakages, and facilitate real-time monitoring of Social Security programs. Funding mechanisms. The Code establishes robust and sustainable funding through balanced tripartite contributions from employers, employees, and government. This flexible yet structured approach ensures the long-term financial viability of Social Security schemes. The Code on Social Security, 2020 represents a transformative reform in India's social protection landscape, delivering comprehensive coverage while optimizing administrative processes and enhancing compliance. It signals a decisive shift from fragmented, employment-based protections toward an inclusive system that embraces diverse work arrangements in today's dynamic economy. Successful implementation demands synchronized efforts from central and state governments, employers, trade unions, and other key stakeholders. Ongoing evaluation and responsive adaptations based on implementation experiences will be essential to achieving the Code's core mission of universal Social Security coverage. To facilitate understanding of implementation practicalities, a comprehensive resource of questions with straightforward answers is available as a supplementary guide. This document addresses critical concerns regarding registration procedures, contribution calculations, benefit eligibility, grievance resolution mechanisms, and transitional provisions to support smooth adoption of the new Social Security framework.